The Appellate Division First Department is now in session. Good afternoon. Happy New Year to everyone. Welcome to the Appellate Division First Department's virtual argument session. I'm going to begin by calling the calendar. Please listen carefully. I'll call the case. You state your name and the party whom you represent, and I will confirm your time. People versus Lorenzo Sykes.
Yes, Emma Schwartz on behalf of Mr. Sykes.
6 and 2. Respondent.
Thank you.
Dana Poole from the Manhattan DA's office on behalf of the people.
6 minutes.
Thank you.
Just going to increase my volume a minute. Okay. Mount Holly versus Greenway USA is submitted. E. Dibby versus Sibylis DP is submitted. Weinstein versus WWW Associates is submitted. People versus Kenneth Payne for the appellant.
Yes, Whitney Elliott of the Legal Aid Society for the appellant, Kenneth Payne, Your Honor.
6 and 1 for the respondent.
Carl Dubel for the people from the Manhattan District Attorney's Office.
4 minutes. Ordonez versus One City for the appellant.
For the appellant, Christopher Donadio with the law firm of Garrett Coniston.
5 and 2 for the respondent.
Patrick Lawless for respondent, One City Block, respondents, One City Block and Taconic Management, 5 minutes.
Thank you.
Meredith, oh, sorry.
Yes, sorry, Meredith Drucker.
Yeah, Meredith Nolan for Waldorf Holding Corporation respondents, 5 minutes.
Yes. Andrea McShann, I'm sorry, Drug Policy versus New York City Tax Commission for the appellant.
Yes, Paul DeSena from the City of New York.
William Josephson for response.
I'm sorry, could you repeat that, please? For the appellant?
My name is the appellant, Paul DeSena from the City of New York.
Okay, just so you know, it was very difficult to hear you just then, but 6 minutes. And for the respondent?
William Josephson for DTA.
6 minutes. West 14th and 150 versus New York State DHCR for the appellant.
For the appellant, Nati Winiarski from the law firm of Cook and Marino, Winiarski and Bittens.
4 and 1. For the respondent.
For the respondent, New York State Division of Housing and Community Renewal, Mark F. Palomino, Robert M. Barris of Council.
4 minutes.
And for the intervener, Victor Kim, this is Jordan Hughley from the New York Legal Assistance Group.
4 minutes. Ryan versus the City of New York for the appellant.
Good afternoon for the appellant, Neil Fingston.
And that's 5 and 2 for the respondent.
Yes, good afternoon, Wamika GB from the New York Law Department for the respondent.
5 minutes. I'm going to call that case last as I am recused from that case and Justice Sally Manzanet will be vouched in. Bear versus Bear for the appellant.
Todd Harrison for the appellant, McDermott, Will and Emery.
5 and 2 for the respondent.
Yeah, good afternoon, Your Honor. Scott Klein from Mintz and Gold LLP for the respondent, and I would like to introduce my colleague, Attorney Thomas Briggs, a member of the Bar of the State of Delaware, who has been admitted pro hoc vice for this appeal. I respectfully request that Mr. Briggs be permitted to argue this appeal before this court on behalf of the respondent. Thank you, Judge.
I'll grant that request, and it's 5 minutes for Mr. Briggs.
Thank you, Your Honor.
Castronovo versus Dentsply Sirona for the appellant.
William Fredericks for the appellant.
6 and 2 for the respondent.
Christopher Malloy for the respondents.
That's 6 and 2. And this case will also be called at the end of the calendar. Justice Sally Ann Scarpullo is recused, and again, Justice Sally Manzanet is vouched in. People versus Adam Arenas is submitted. Board of Managers versus JMA Consultants for the appellant.
The appellant, Salvatore GM Piccolo, Your Honor.
6 minutes for the respondent.
For the respondent, Thomas Juneau from Armstrong Teasdale.
5 minutes. Malaku versus AGA 15th Street for the appellant.
David Paris.
Good afternoon.
Yeah.
Oh,
Actually, I
I'm
think you're the
sorry. I'm
respondent,
the
Mr.
respondent.
Parisman.
I'm sorry, I'm asking
Good
for the
afternoon.
appellant. I think it's Robert Baxter.
It's me, Sim Shapiro, Your Honor, on
Sim
behalf of the firm Baxter Smith and Shapiro, on behalf of the defendants, appellants, respondent, College of St. Francis Xavier, and Richter and Radner.
And for the respondent,
David Parisman for plaintiff respondent.
4 minutes. And I'm sorry, for Mr. Shapiro, it was 4 and 1. I don't think I stated that.
And Michael Feinberg from O'Toole Scrivo on behalf of the defendants, respondents, appellants.
And that's 4 minutes as well. Singh versus the City of New York. For the appellant, I'm sorry, that's submitted. Bryant versus Garcia for the appellant. Is there a Teresa DeFonso?
I apologize, Your Honor. Good afternoon. Teresa DeFonso of counsel to legal aid for the appellant.
Okay, that's 5 and 1. And for the respondent,
Andrew Lupin for the New York City Housing Authority respondents.
5 minutes.
Thank you.
511 West 25th Street versus West Kids 25. That has been withdrawn per stipulation. Perez versus Table Run Estates is submitted. Perez versus 2141 LLC is submitted. Counsel, please remember, as always, that we have your briefs, we have your records, and we are fully familiar with the facts of your case, so please go directly to the points that you wish to make. Also, as is customary, please don't speak when a justice is speaking. It's particularly important with our virtual arguments so that we can hear the questions, that you can hear the questions that are asked. And finally, please keep your mics muted. Try to remember to turn them on thereafter. We'll help to remind you. Thank you for your patience and your cooperation. The first case for argument is People versus Lorenzo Sykes.
Yes, Emma Schriefter on behalf of Mr. Lorenzo Sykes from the Office of the Appellate Defender. May I proceed?
Yes, please.
Thank you. The officers aggressively enter Mr. Sykes' home based on little information from the complainant, Ms. Bior.
So, counsel, just to begin, the complainant was hysterical in the, at least in the testimony of the officers, and she said that a man raped her and kept a firearm under his pillow. And she was actively hysterical and pointing in the direction of the house. Those are the circumstances under which they went to the home. Were those circumstances not exigent?
They were not. To begin, she never claimed that these crimes happened recently, as is necessary for a finding of exigency. She may have been hysterical, but that is that's necessary or totally reasonable for someone who has suffered such a trauma. And she never stated that Mr. Sykes was in fact armed, rather that she just saw a gun under his pillow. The question here is whether
if he was in the house and he had, if he was in the house and he had a gun under his pillow, doesn't that mean he had access to a weapon or weapons? I mean, did he need to have it on his person, or did it need to merely be accessible to him?
Well, in other cases, exigency has been found where the suspect is still wielding a weapon or is likely in possession of a weapon during a crime that very recently occurred. And there was no allegation that this crime had occurred recently.
Well, Counselor, when the police, this is Justice Weber, I'm sorry. When the police came up on the scene, she was exiting an ambulance. And upon exiting the ambulance, she stated that she had been raped and that the person who raped her was still in the building, and she pointed to the brownstone. So would that not suggest that this incident had occurred fairly recent to when the police came up on the scene?
Well, the lieutenant testified that she never gave a timeline and never specifically alleged that this had happened earlier that day or at any point. It was unclear when that had happened. And again, the question is whether the suspect would react violently where he first warned of entry, and that is not present here, where it was unclear that this happened recently and that he had access to a weapon at some point, but at an unknown point. It was also not clear that the suspect would have fled.
Let's assume for a minute that because she was there at the scene in an ambulance, that the ambulance was called because usually an ambulance is called for an immediate need. And she is present and was pointing at the building. She said that he was in there, I believe, with the weapon. So that would satisfy the exigency, that would satisfy his presence, that would satisfy a weapon.
Your Honor, she didn't claim that he was inside with a weapon, rather that at some unknown point in time, she had seen a gun under the pillow, and it's not clear that he would have then had access to this gun or have been armed with this gun during entry into the home.
Well, why would it not be sufficient for the police to simply know that there are weapons at the location and that those weapons at the location were fairly recent?
Well, there's no indication that he would grab the gun under these circumstances. Again, it's not.
So you're stating that although there may be weapons at a location, there has to be some type of indication that the individual would actually use those weapons if, in fact, the police came to the premises?
Yes, well, we see that in other cases where it's a recent crime that the defendant or the suspect is still in possession of that weapon or still wielding the weapon. She never stated that the weapon was used during these crimes or that he was armed during these crimes.
She stated that she had been held against her will for at least 4 days and that she had been raped repeatedly.
And that there were other people who may have been raped as well, that there were other people inside.
Correct, but this was, again, there was no allegation or no time frame given such that exigency existed, and it was pure speculation that victims were still in the home or that there were other victims at all.
Well, that she left the building and said that there were other victims is speculation?
Yes, she didn't say there were other victims, but there were other women.
Other women?
Yes, and it was not alleged until later after the arrest that there was sex trafficking involved. So there's no reason to believe that at the time the officers would think that other women were in the home being sex trafficked.
I don't know that sex trafficking is really relevant. The issue is whether there were whether you call it sex trafficking or you just call it an individual who has women there and who is raping those individuals. She also stated that there were other females who were assisting in her having been raped and others being raped as well.
Yes, that is correct. But again, the question is the urgency of the situation and whether the suspect would react violently. And this was not a situation to suggest violent reaction where he first warned of the entry. I see my time is up, but if I could quickly address the second
rebuttal
point.
time. You have some rebuttal time. Okay, the respondent? Ms. Poole?
Yes, Your Honor. Am I visible?
Yes.
Okay, great. So this was obviously an exigent circumstance. This is a woman who had claimed that she'd been raped. She'd been held against her will for several days, and that there was a gun in the house. The police had every reason to believe that it was at least possible that a person who kept a gun in their house would respond to the police utilizing that gun. And, in
was
this
this an
situation,
instance where they had enough information and they should have gotten a warrant?
well, given the fact that she had said that there were other women in that same house where she had been held against her will and had been raped and there was a weapon, no, I think this was a situation where the Police
And that there was
needed
an ambulance there, suggesting perhaps that there was some emergency?
Certainly, Your Honor. And the fact that she had said she'd been held against her will, the fact that, you know, it's now nighttime, she is in an ambulance, that suggested that she had just gotten out of that house, which was in fact the case.
What was the radio run? What did the radio run say? It was just a person in need of assistance?
I believe that's correct, Your Honor. But when the officers arrived, the woman was still inside the ambulance. They spoke with her, and she made the allegations that she had been raped and held against her will. So this is a situation where, you know, the police, they took, you know, certain safety precautions. They checked whether there were any other egresses. And then they knocked on the door and they waited until someone came to the door. So certainly that is a situation where someone who had a gun in the house would have had time to retrieve that gun. And the police officers were clearly very concerned about that possibility. Moreover, their actions following the arrest also indicate that those were their concerns. They weren't rushing into the house trying to search for evidence or anything like that. They were concerned that there were other women. There might be other women, other victims in that house. And so they just did a sweep of the house to make sure that there was actually no one else in danger. And that did appear to be the situation. But obviously they didn't know that as soon as these two men came to the door. Also,
I was going to ask you to move on to a different point, which had to do with the admission of the evidence with regard to publishing and advertising for prostitution.
Absolutely. So in this situation, the people were charged with proving that the defendant was running this prostitution business. He was running a house of prostitution. And the fact that he had been advertising and been involved in the advertising for this business for a period of time before the time period alleged in the indictment went to show that in fact this was an operating business that the victim was brought into, and so that was appropriate. In this case, also, it is important to keep in mind
wouldn't the testimony of the person who was working as the prostitute have established that sufficiently? Did that go too far in allowing that information?
Well, Your Honor, this was corroborative of her testimony. And this is a case where that, in many instances came down to a credibility call. And this is a situation in which, she gave testimony about the way that the advertisements involving her were put together and posted. And the defendant was claiming that he really had nothing to do with it, even though it was on his phone and things like that. So proof that, in fact, this was the normal course of business. What she was describing was actually the normal course of this business that he was operating.
So so counsel, then it went to a common scheme or plan?
If it were to be considered Molyneux, absolutely. But it also is just direct proof of the business that this defendant was operating, and that this particular victim was brought into for a shorter amount of time than the entire operation of the business.
I was going to ask whether there was a curative, but I noted that it was a non-jury trial. Is that correct?
That's right, Your Honor. And there was a lot of discussion about how much of this information would be brought in. And the judge made very clear, that he understood the relevance of it. It wasn't his primary concern. He was going to allow some of it. He wasn't going to be prejudiced. He understood what the competing arguments were going to be. So this isn't a situation where we have to worry that, a lay jury might interpret this the wrong way. We're dealing with a judge who understood what the parameters of this evidence were and what it should be considered for.
Thank you. Your time is up. Thank you.
Thank you, Anna.
Ms. Schrefter, is it?
Yes. Schrefter, yes. To address the patent issue, I'd like to remind this court that there are 3 factors that respondent urges that this court cannot rely upon. Those are the gravity of the circumstances, probable cause, and the peaceful entry. These circumstances are not properly before the court. They were all presented by the prosecution to the lower court, but impliedly rejected when omitted from the analysis. And under LaFontaine and Concepcion, this court could not then use those factors to find for a finding of exigent circumstances. To move on to the Molyneux point, I would like to point out that these 144 advertisements going back a month and a half outside of the indictment period were not in fact corroborative of Ms. Bior's testimony, because Ms. Bior was, or Mr. Sykes had not met Ms. Bior before this indictment period. And they also were indicative of Mr. Sykes' posting of these advertisements, but were not necessary to draw out additional evidence where there were 5 other advertisements admitted during the time of the indictment, and they were purely cumulatively unnecessary. Again, this was 144 advertisements, many of them posted by the co-defendants rather than Mr. Sykes himself. And they were not necessary here when there was other evidence that the judge could have drawn on. And I would say also that this was Molyneux evidence rather than, as respondent urges that it's not, because it was used to show other bad acts prior to the crimes here. And certainly this court cannot rely on a decision that is otherwise not relevant, which would be for Musa, which respondent relies on. And in that situation, there were different crimes at issue. These were different services, different women, and thus this court should find that this evidence should have not been admitted. I ask again that the court reverse the suppression ruling, or an alternative reverse the convictions.
Thank you.
Thank you.
People versus Kenneth Payne.
Yes, good afternoon, Your Honor. Whitney Elliott of the Legal Aid Society for Appellant Mr. Kenneth Payne. Just want to emphasize some of the factors for why we think Mr. Payne's 6-year prison sentence is excessive in this case.
Let me just ask you from the beginning, what is the range here that he faced given the reduction of the plea he was given?
2 points, Your Honor. First, the range was 3.5 to 15, but the second point, there was no reduction in the range. The first 2 counts were both—
No, not a reduction in the range, a reduction in the charge to which he pled.
No,
wasn't it a lesser charge?
No, Your Honor. With respect, the top 2 counts were both C violence, and he pleaded guilty to the second count, which was a C violent. Yes.
Okay, sorry. Thank you. Yes.
So first, this was his first conviction of any kind. Second, at the time of the incident in this case, Mr. Payne was working, living with his partner, paying his bills, and supporting his young daughter. He had many supportive family members, including his mother's partner, Deborah Banks, his grandmother, his sister. And the whole incident happened here because Mr. Payne was protecting his vulnerable mother from an abusive relationship. And next, because of that, the unique circumstances of this case, something like this is—
Counsel, this is Judge Gonzalez, but didn't Mr. Payne drive up from out of state with a loaded gun into New York City in order to address a situation that concerned him, which obviously had to do with his mother? Doesn't that come into play?
2 points, Your Honor. There was evidence in the record in the VDF, for example. He lived in Maryland, but had family and occasionally stayed with family in the city. Second, in terms of whether he drove up with a loaded gun, that certainly was not established here. Now, this, of course—
Counsel, this is Justice Weber. Regardless of whether he drove up with a loaded gun from Maryland or another state, the fact remains that he did enter the location or went to location with that loaded gun. Is that not correct?
No, that is not correct, Your Honor. That was not established on the facts here. The complaining witness, that was the complaining witness's version of what
So
happened.
was he ever found with a loaded gun? Was he charged with the possession? Was he found in possession of the weapon?
Yes, he was, Your Honor. At the time he was arrested, he was found in possession of the gun, and we think the record shows that is what he pleaded guilty to. But he had his version of how he came into possession of the gun, which very much differed from the complaining witnesses.
Was there not testimony that he actually discharged the weapon? He fired the weapon?
Well, the complaint, couple things, Your Honor. That's not settled on this record here. The complaining witness had his version of it. Mr. Payne ultimately only pleaded guilty to criminal possession of a loaded firearm, not with the intent to use it. Mr. Payne had his account that it was the complaining witness's gun, and they wrestled over it, and the gun discharged 3 times. The complaining witness had his version.
But the shells, counsel, were found in the hallway, and the defendants testified, unless I'm wrong, or implied that the shooting, the use of the weapon was inside the apartment.
Oh, I think there was no dispute that the gun discharged. There was a dispute about exactly how it discharged.
And did this happen inside the apartment or in the hallway with the door closed? Where did this happen?
It happened in the apartment building, and it happened. I think there was agreement that it was in the hallway, and probably with the door closed. Okay. But again, who originally had the gun, exactly
and I'm
how.
assuming, Counselor, that your position is that bullets don't go through doors, closed doors, right? I mean, the fact that the door was closed does not mean that the bullets could not go through the closed door. Is that correct? Or any closed door in the hall? And Counsel, also, when you were talking about the possible sentences, I wanted to be clear. Was he also, was there consecutive time also a possibility? The people never asked for consecutive time, did they? But was that a possibility?
So I think on our view, no. I mean, I think the other side has to assume the truth of the complaining witness's version of what happened, which again was never established and is not decided by my client's guilty plea, because he only pleaded guilty to simple possession of the loaded firearm, we think, at the time of his arrest. And just as we point out in our reply brief, assuming the complaining witness's version of what happened and then affirming a sentence on that assumption would be directly inconsistent with the Jua case, which we cite, because it would involve basing a sentence on unsubstantiated charged conduct. My client never admitted to those facts. They were not otherwise established by the evidence in the record. It's just the complaining witness's version of what happened. But I do want to say, putting all of that to one side, we still think that the sentence is excessive because he was living
Counsel, this is Judge Scarpula. Didn't he agree to that sentence? Right? It was a negotiated bargain sentence. He was facing 3 to 15. The offer was 6, and he said, yes, I'll take it. And you're saying he took it even though his position was, the only thing I did was pick up a gun that I don't know where it came from and ran away, and yet he agreed to take a sentence of 6 years for that?
Yes, Your Honor, and that offer came from the court, and he agreed to take that sentence with the court.
He bargained, and he got what he bargained for, correct? He could have gone to trial. He could have testified to everything that you're saying right now, but he didn't. He chose to avoid that and take the 6 years, right? Because maybe his story was a complete lie. We'll never know whether it was the truth or the lie. He chose instead to take his 6 years, right?
Well, he did, because he agreed and he admitted consistently from the very time of his arrest that he was in possession of the gun.
But Counsel, I'm assuming that your position would be that he should not in any way be penalized for the fact that he did not exercise his right to go to trial. Is that correct?
I don't think so. And
exactly. So the fact that he did plead guilty, which is a consideration. However, that is not to say that, again, your argument is well taken in terms of it being excessive or that it being an excessive sentence. The fact that he did not exercise his right to go to trial, is that correct? He shouldn't be penalized for that, is that correct?
I agree, Your Honor, and he consistently accepted responsibility and never disputed that he had possession of the gun.
Thank you.
Thank you, Your Honor.
Good afternoon, Your
Mr. Goldfein?
Good afternoon, Your Honors. It's Carl Dubel for the people. Based on the seriousness of this offense, we believe defendant's sentence is entirely appropriate. He did, in fact, bring a loaded gun to his mother's ex-boyfriend's apartment, who he admittedly never liked. He went there ready for an argument. Once the argument was over, he had left the apartment and the door was closed, and he had every opportunity to walk away. Instead, he decided to take the gun and fire it 3 times into the apartment door. This is true, none of the bullets breached the door, but there was, in fact, a 4-year-old girl behind the door and inside the apartment, which defendant knew about because he was previously in there. Just to push back on
was it taken into consideration? So this was his plea, obviously, and it was, I guess he was aware of the sentence when he pled guilty. Was it taken into consideration that he had that he had no conviction at all? That he had no record?
Yes, Your Honor. Though this is defendant's first conviction, that is taken into account by his near minimum sentence on this charge. It is a C violent felony, and even for a first-time offense,
it's 2.5 years over the minimum, isn't it?
Yes, but the minimum, I believe, was 3.5, and he could have faced up to 15. So that
it's closer to the minimum. Mm-hmm.
Agreed, and we believe that the fact that it was first conviction is taken into the fact by it is a lower sentence. And also, going back, this was, an incredibly dangerous thing that could have led to a serious injury. It's very lucky that those bullets did not breach the door.
Aren't these C felonies, aren't they all very serious? I mean, isn't that the nature of it?
This is true, but
I'm just curious. I mean, he did something that was clearly outrageous and extraordinarily dangerous, which is, I think, the nature of the plea. So I'm just thinking, for a person who had no record, this is his first conviction, I'm just wondering, wasn't that taken into consideration in the plea itself? I understand there's a range, and the range is permitted.
Yeah, it was taken into, and the other mitigating factors that defendant brings up were taken into consideration. But based on the charges and all the other, the fact that there was a young girl involved and defendant did, as I believe one of the justices pointed out earlier, he did come from another state. There's no evidence that he brought the gun from another state, but he did come to the state and did engage in this conduct. But
that's where I think that he spent part of his life in the state, although he also spent time in the South, and his mother lived there. So coming to the state was not unusual. We don't know that he came specifically to engage in this activity. I don't think he learned about the activity until he came to the state. But in any case, there's no evidence of any of that premeditated driving up with a weapon to do anything. Isn't that right?
This is true. There's no evidence that he premeditated this case before he came here, but it's also not a crime that was a heat of passion. Like he went to the apartment with a friend, prepared for an argument, and then after the argument, he had every opportunity to leave, and that's when he committed the actions that led to these charges.
Thank you.
If there's no further questions, we just ask that you affirm.
Thank you.
Thank you.
Is it Mr. Elliott?
Yes, Your Honor.
Have
Thank
1 minute.
So a couple quick points in rebuttal. Again, as we point out in our reply brief, assuming the complaining witness's version of the facts would be inconsistent with JUA, and I think that they depend on that for their argument. And I just want to emphasize, again, at the time of this offense, Mr. Payne was working, living with a partner, paying his bills, supporting a young daughter, doing everything to become a productive man, nurturing to his family. He's done 3.5 years already, Your Honor. He was doing the right thing at the time of this offense. The incident resulted from him protecting his vulnerable mother from an abusive relationship.
Well, I don't think you mean that completely. He wasn't doing the right thing at the time of the offense. Maybe getting the police involved and saying that this man had threatened or beaten his mother would have been the right thing, not going over there and then firing a weapon, regardless of how the weapon came into being in his possession. In any case, I think we have your point.
Okay, thank you, Your Honor.
Thank you. Ordonez, Carlos Ordonez versus One City Block.
Good afternoon, Your Honors.
Good afternoon. Are you speaking?
Can I begin? Yes.
Yes, I can.
All right.
Okay, sure.
That's okay.
Begin.
May it please the court. My name is Chris Donadio, counsel for the appellant, Mr. Ordonez, in this matter. It is the position of appellant that the partial motion for summary judgment was wrongfully denied by the IAS court for 3 reasons. 1, there were absolutely no railings, undisputed, no railings on the scaffold upon which Mr. Ordonez fell and was injured. Second, there are absolutely no material facts that are in dispute regarding the happening of the incident. And 3, there is no evidence that Mr. Ordonez was in any way the sole proximate cause of his fall and his injuries. Mr. Ordonez was working on a mobile scaffold at a large construction site in Manhattan.
Does it matter that the scaffold, does it matter that Mr. Ordonez said he didn't get off of the scaffold to lock the wheels?
It does not matter, Your Honor, because that is not a material fact that matters for our analysis under 240.
Would that be comparative negligence in a strict liability case if this were found to be so?
Absolutely, Your Honor. That's why it's not a material fact, because it would go to comparative negligence, just as it did in the Solage case, which was before this court, which dare we ever say a case has identical facts, but were virtually identical to this case. In this case, just as in Solage, there were allegations that the plaintiff who fell from a mobile scaffold that had no railings whatsoever, climbed down and maybe unlocked wheels of a mobile scaffold. As this court said in Solage, that disputed fact was not material because it only goes at best to comparative negligence. And that's exactly what we have here.
In this case, he says he didn't climb down. So we know he remained at the top of the scaffold. No one saw him climb down, but somebody who was at the bottom says that they locked the wheels. So
correct. Yes,
there's nothing to dispute that person locked the wheels, actually, in any case.
Correct. And regardless of whatever the testimony was on the wheels, the one thing that was consistent of every single witness in this case, and even all of the defendants, no railings whatsoever. Okay. Thank you, Your Honor.
Are there any questions? Thank you. For the respondent?
Patrick Lawless for Wilson Elser for respondent, One City Block and Taconic Management. The court below properly found that there were issues of fact, whether the plaintiff
What's the fact about the railing? Was there any fact? I'm sorry. Was there any fact but that there were no rails?
There's issues
Is there
of fact
question
as to
there was no? Yes, go ahead.
No, there's no question that there were no railings, but there's issues of fact whether or not that there was a safety harness available to the plaintiff, and there's issues of fact as to how tall the scaffold was and whether railings
Counsel,
were
this is
required.
Justice Weber. To that point, perhaps I missed it, but in looking in the record, I did not see any affidavit from Robles. And I thought that the plaintiff had stated that Robles was the individual who gave him his instructions in terms of the use of the task as well as the scaffolding. But I didn't see anything from Robles.
No, I believe that's not in a record, but we had the testimony from Supervisor Mr. Marone that there were harnesses available at the site, and there's
but I thought
differing testimony between the plaintiff and his.
I thought Mr. Robles, who was the maintenance, who was the plaintiff's foreman, and he was the one who was giving the instructions, or was tasked with giving instructions to the plaintiff. Is that not correct?
According to the plaintiff, but the plaintiff also testified, though, that he was aware that he was not supposed to be sitting on top of the scaffold while it's being used, was aware that is aware of how it was supposed to be used. He claimed that he was unaware whether or not there were harnesses available at the site, but Mr. Marone said definitively that there were harnesses available at the site, and there's differing testimony between plaintiff and his coworker as to how tall the scaffold was and whether railings would have been required. And also there's conflicting testimony as to how the accident happened. The plaintiff claimed that the scaffold moved because the wheels weren't locked, where his coworker said that the wheels were locked, and that's not how the accident. So giving all these factors, the denial of summary judgment was appropriate.
I thought the client said that he reached up and he stumbled back. He lost his balance and stumbled backwards.
He also indicated that the scaffold moved and that the wheels weren't locked. That was the reason why he fell.
Either way, whether the scaffold moved or he reached up, either way, it was the absence of the railing that caused him to go over.
I think there's issues of fact in that regard, whether railings were required under these circumstances, and also whether the plaintiff should have been wearing a harness and whether harnesses were available to him at the work site.
But counsel, didn't the plaintiff testify that he never received instructions to wear a harness? And isn't it true that there's no counter to that because there's no affidavit or deposition testimony of Mr. Robles in this regard?
Well, I think Mr. Marone, Mr. Marone was the one who oversaw the entire site.
But again, that was my point, Councilor, that it was Mr. Robles who was giving the instructions to the plaintiff. He was the direct supervisor.
I don't think they
oversaw the entire site.
Mr. Lawless, there's a problem with your transmission.
It's okay. I think we heard you in the end. Any other questions? Thank you. Mr. Drucker?
Oh, yes.
Can everyone hear me now?
Is it? Mr. Lawless, we heard your final statement, and I'm now moving on to Mr. Drucker, I believe, Nolan Drucker.
Meredith Drucker-Nolan, yes, Your Honor.
Meredith Drucker-Nolan, sorry, yes.
Oh, no problem, that's okay. Yes, Your Honors, good afternoon. I represent the defendant respondents, the W5 holding groups entities. I think the court is well aware of the facts here. I would just like to point out that in this case where there's a lot of inconsistent testimony regarding whether or not he locked the wheels, and since the scaffold itself was not defective, there's an issue as to whether or not plaintiff was provided with an adequate safety device. The scaffold didn't collapse, it didn't break or otherwise. He knew that if he had locked the wheels, the scaffold would not have moved and he would not have fallen.
Martinez stated that he locked the wheels.
Without question, he stated it, without hesitation, and with no challenge.
Right, except for that plaintiff disputed that, and I think that
plaintiff didn't dispute it. Plaintiff said, I was on the top, I never went down, I never locked the wheels. The other gentleman said, I was at the ground, I locked the wheels before I walked away.
The version of the testimony I recall from the plaintiff is that the wheels were not locked at that moment.
No, well, he testified that he did not lock the wheels because he was on top of the scaffolding. Martinez stated that he walked by, saw that the wheels were not locked, and that Martinez, locked the wheels. So you can glean from that since the plaintiff was on top of the scaffolding, he did not know that Martinez had locked the wheels.
Right. Yes, Your Honor. I would say this inconsistent testimony raises a tribal issue of fact regarding whether additional safety devices needed to be provided, which is what the lower court found in this case. that given that testimony and the inconsistent versions, that it is not enough to impose absolute liability in this case under the labor law. And I would just say that the Silage case, there's not enough facts in that case, and there's also no evidence to know if there was misuse by the plaintiff. I would just like to make one final point regarding whether there's a question of fact if the W-5 entity is even a proper labor law 240 defendant. It was not the general contractor in this case, and no one from the W-5 group supervised or directed the plaintiff's work. Admittedly, all supervision and control was from Calvin.
Didn't Mr. Marone, the co-owner of the W-5 group, say that the group had the authority to close the site, stop work, had authority to hire and did hire subcontractors? Didn't it have, at the end of the day, didn't the W-5 group have authority over the work being done when the plaintiff was being injured?
Not at the exact time of the moment that the work was being done. It had, Ms. Marone testified at the beginning. Right, not at that moment. He did not have, he had general supervisory control, but was not on the site on a daily basis.
I didn't use the term supervisory control. I used the term authority because that's what the standard refers to. It's not whether the defendant actually supervised the work, but whether it had the authority to do so.
Right. I understand, Your Honor. I would say in this case, there's a question of fact as to whether or not that is the situation, because the plaintiff testified that all of his direction and control was from Calvin and Rubel as the foreman in this case. Otherwise, I'll rely on my brief if the bench doesn't have any other questions. Thank you.
Back to Mr. Donadio.
Yes. And just picking up with the argument right there, in fact, Mr. Marone not only said that W-5 had the ability to shut down the work or stop it, they did, in fact, shut the work down in this case after the incident occurred. In addition, just picking up of what Justice Gonzalez said regarding this argument about the harness, yes, there's absolutely no evidence that anyone ever told Mr. Ordonez that he had to wear a harness. And even if he did, even if there was a directive, his failure to utilize a harness in this case because of the lack of safety rails would again only go to comparative negligence. And finally, in terms of any issue about the height of the scaffold, as the First Department made very clear in the Vergara case, there is absolutely no height requirement when it comes to railings on mobile scaffolds. They all require them, and this court in that case cited to correctly the Industrial Code, section 23.5.18b, which requires safety railings, 4 of them on all mobile scaffold, regardless of size. And if there are no further questions, we also rest on our brief.
Thank you. Thank you all.
Thank you.
Drug policy versus matter of drug policy alliance versus New York City Tax Commission and New York City Department of Finance.
You're on.
Yes, Your Honor.
Yes, Your Honor.
Yes, thank you. We begin with the appellant. I think it's Andrea Chan, is it?
It's Paul DeSena representing
Paul
the city.
DeSena, sorry. Okay. Why don't you go ahead?
And I'm actually getting feedback from some source.
Yes, I'll just ask that everyone who is not on this case, everyone turn off your mic. Even if you're on this matter, turn off your mic until it's your time to speak. Okay, so thank you.
And secondly, I would thank you, Your Honor. And secondly, I would ask the court if I could reserve 1 minute of my time for rebuttal.
5 and 1, yes, okay.
Thank you so much. From the city's perspective in this case, the issue is rather clear. The lower court erred substantially and in several different ways in finding that petitioner's Manhattan condominium was exempt under real property tax law, section 420A. Sorry about that. The first way in which the lower court erred substantially was in failing to afford the tax commission any deference in this matter. As a municipal agency considering a statute with which it has specialized experience, the tax commission was entitled to deference. And quite frankly, the lower court erred in failing to afford them that deference. Furthermore, even a cursory review of the tax commission's decision in this matter, located at page 562 in the record, reveals an eminently rational decision with a sound basis in reason. The tax commission.
Counsel, is there any error in the fact that the tax commission's decision is one that I mean, when the tax commission had the hearing officer who presided at the hearing wasn't the person who signed the decision. The tax commissioner himself signed the decision, or the president of the tax commission, which usurped, it seemed, the power of the individual hearing officer to decide.
Well, Your Honor, the determination itself before the tax commission was issued by Ms. Hoffman. However, Mr. Glenn Newman did sign the determination for the simple reason that he was commanded to do so by law. Under Section 11-216 of the New York City Administrative Code, the president of the tax commission is required to concur in determinations that.
Counsel, isn't that different? Aren't you parsing language? There's no signature by the hearing officer. So how can that decision be reviewed?
Well, Your Honors, even in such cases where a justice of the Supreme Court, say, signs his own decision, that decision can be reviewed through renewal and re-argument. There's nothing vitiated by having President Newman sign the tax commission's determination here. Number one, because he was required to do so by law. And number two, they could have always just appealed the decision anyway. And that's really.
Counselor, in terms of the hearing itself, the other thing, not only in terms of who signed it, but was there not also an issue in terms of the failure to allow the cross-examination of the Department of the Director of Exemptions, the cross-examination of that individual?
And that's a great point, Your Honor, and I'm glad you asked that question. This is traced back to a fundamental misunderstanding that the lower court had of the tax commission's petitioner's proceedings before the tax commission. That fundamental misunderstanding is simply this: the lower court held that hearing was subject to the rules of the City Administrative Procedure Act. They weren't. They were held pursuant to Section 164 of the New York City Charter. That hearing was a voluntary hearing, not held pursuant to direction of law. And so protections such as cross-examination and other protections that would usually attach to an adjudicative hearing under the City Administrative Procedures Act don't attach here. And what's even more important is
Was that witness actually called by the other side?
He never was. And that's the other point.
So that it didn't raise that. Mm-hmm.
Right. There's no direct, and there can be no cross when there's no direct. And this is all part and parcel again with the lower courts. And it's our belief that the lower court's decision is just shot through with error here. And
well, let's go back then to the issue with regard to the signature, because still it seems, I don't know how the party would, the signature was absent. So it seemed like it passed that the hearing officer really didn't sign or write or do anything with regard to that decision at all. Even though the name was on it, it was not, as is customary as well, for the signature to be on it.
I mean, Your Honor, at this point, it's my understanding that that all procedures regarding the actual hearing determination were proper and held.
Well, what about the constitutional issues? Were those addressed?
They were never addressed by the lower court, Your Honor. And in fact, Justice Wooten twice declined to review on any constitutional issues. We would actually ask this court to decline to review on any constitutional issues. But to the degree this court would like to take them up, none of their constitutional issues are even pled properly. When you allege a constitutional deprivation by a municipality, you have to plead Monell. They haven't done that, nor have they pled any sort of vague policy or practice on the part of the tax commission. One instance of statutory interpretation rationally taken does not a vague policy make. And furthermore, and it's all in our brief, there's due process concerns, there's substantive due process they raise. There's no fundamental right to a real estate property tax exemption. I mean, really the crux of the error in the lower court's decision is their total misunderstanding of Section 420A of the RPTL.
So, Counselor, if I can get back to the signature, one last question. Is it customary for the hearing officer not to sign the final determination? Is that something that is customary?
It is my understanding that it is customary in cases subject to 11-216 for the president of the tax commission to concur. The exact form, the exact format of the hearing officer's issuance of the original decision and
Counsel,
the format.
if I may, with what did he concur if there was no signature by the hearing officer?
He concurred with the type decision, which was, I would argue was signed at the top by Ms. Hoffman.
But it wasn't signed by her. The name was stated. Anyway, thank you. Your time is up. You have 1 minute rebuttal. Let's move on to Mr. Josephson.
Yes, thank you, Mr. William Josephson for Drug Policy Alliance. Happy New Year from Lincoln, Nebraska.
That's a long way away, sure.
The court is 100% correct here. The hearing officer patiently heard voluminous evidence. She said at the close of the evidence she would issue a decision. She never issued a decision. We waited, nothing happened. The president of the tax commission, Glenn Newman, as the court seems well aware, usurped her function. We don't know why. And he did his own examination of the facts. He was never present at the hearing, and he issued an opinion which is based in part on the record and in part on his own research, which DPA never had an opportunity to rebut. Also, with respect to the cross-examination issue, the Oberman, the finance officer who issued the advocacy opinion, was present in the courtroom, offered to testify. The hearing officer
offered to testify. He may have offered to. I'm sorry. He may have offered to testify, but yes, no. Let's assume he offered to testify, but he wasn't called to testify, and therefore there's no basis to cross-examine. And it sounds like that's discretionary.
Yes, she rejected his proffer, and I then made a motion that he be asked to be able to testify, which she wrongfully denied.
Isn't that discretionary?
I don't think it's discretionary. I think an important witness who issued the crucial document in this case is there and wants to testify as to why he did it, how he did it, what he relied upon. I can't imagine anything that is more pertinent to this case than his testimony. May I go on, Your Honor?
I think I see a question from.
Yeah, I don't understand that. What witnesses test about facts? What fact could that witness testify to?
What is in his head when he decided
Why
to
is that
speak
relevant? Why would that make any difference?
Your Honor.
Okay.
When I first argued this case before this court, the first question from the court was, isn't Symphony Space controlling? Symphony Space is controlling here. That city has never answered that question, and that question is still before the court. And Symphony Space has just been reaffirmed, as you know, by the Second Department in the town of Islip case.
That might have been a question that was asked, but I don't know that it was the result of the decision, but I can't.
Well, Justice Wooten, in two very carefully considered lengthy opinions in this matter, certainly thought it was controlling, and we agree with him. May I go on, Your Honor?
Yes, please. You should finish up.
My colleague has falsely stated that Justice Wooten never decided the constitutional issues. He decided each and every one of the 6 due process issues that the court has referred to in the hearing in our favor. Those are constitutional decisions which entitle us to an award of attorney's fees. With respect to the First Amendment issues, I'll call your attention Ms. Moretti's statement in our brief where she concedes that this was content-based First Amendment regulation by the tax department. The city has never responded to one single case, for example, Arkansas project, that we cited in our brief in favor of our First Amendment position. Justice Wooten elected not to reach those issues. That does not mean that those issues aren't pertinent. They're extremely pertinent. They're central to this case because the city is trying to use its tax power to destroy DPA, and it nearly succeeded. It owes DPA a fortune. DPA has been paying its taxes steadily in order to avoid the 18% punitive penalty for failure to pay. The city owes DPA an enormous amount of refund money to be determined presumably by a special referee on a remand. It owes it pre-judgment interest, it owes it post-judgment interest, and it owes us attorney's fees under 42 U.S.C. 1983 and 88.
Thank you. We're back to you, Mr. DeSena.
Yes, Your Honor, just 2 quick points. First of all, if Mr. Joseph can mute his microphone. First of all, thank you. First of all, under their Article 78 challenge came out in September of 2012. The Tax Commission's determination didn't come out until October of 2012, so it's unclear precisely what they're challenging about the Tax Commission determination. Secondly, if the taxes were so onerous, you would think they would have challenged them in every year. They have not. They only challenged them in one single year, and under the Court of Appeals precedent, each tax year must stand on its own. They only have the 1 year. They only have the 1 year's worth of challenge. And second, and finally, Symphony Space is not controlling, nor is Mohawk Trust. They stand for the Tax Commission doing exactly what the Tax Commission did, which was to look through the technicalities in any application under 420A and find out what petitioner's conduct is, and see whether or not it's exempt. The Tax Commission did that, and they returned a reasonable and rational determination that petitioner was not exempt because their central conduct was pursuing legislative policy change by merely disseminating information to the public. That is not exemptable conduct under 420A, and it was error for Justice Wooten to rule that it was.
Thank you. Thank you both.
Thank you.
Matter of West 147-N150 LLC versus the New York State Division of Housing and Community Renewal.
Good afternoon, Your Honors. My name is Nativ Winiarski from the law firm of Cook, Marino, Winiarski, and Bittens for the appellant. So this case is governed by the Court of Appeals decision in Regina, which confirmed that for Roberts-type matters, it would be improper to penalize landlords who follow DHCR directives. And I specifically—
Except that there's a separate rule here, New York City rules and regulations, that is not the statute that Regina was addressing. And so Regina doesn't apply here.
Well, if you look at specifically footnote 9 of the Regina decision. So in footnote 9 of the Regina decision, if we go back to the Regina decision, we recall that there was 4 cases in which landlord deregulated units based upon certain DHCR directives. Now, once Roberts was issued and applied retroactively via Gersten, the question became, how do you set the rents? And many courts took the position that you had to take the last registered rent pursuant to Rent Stabilization Law 26-517E. A number of courts, including this court and a few decisions that I've argued before this court, disagreed with that position, arguing how can you fault the landlord for failing to register the rents when
the question here is whether or not what DHCR did was arbitrary and capricious, or was based on reason. Was it irrational? It's not irrational.
It's irrational because if you look at footnote 9 of the decision of Regina, it said, and I quote, that freezing the rent for failing to file registrations is inapplicable in Roberts' cases where the failure to file resulted directly from DHCR's endorsement of a misunderstanding of the law. Here, too, if the Court of Appeals has ruled that it's improper for DHCR to penalize a landlord for failing to register an apartment, then it must be equally improper to penalize the landlord in this matter for not providing the tenant with preferential rent riders for leases executed prior to Roberts for the same reason it didn't register the apartment, specifically because in this case it was told by DHCR that the subject apartment had been deregulated. Obviously, stabilization riders, like preferential rent riders, would not be appropriate.
Judge Scarpulo, when did the DHR tell the landlord that the apartment was deregulated? Is there a letter?
No, by law.
No, so the DHCR didn't say anything to the landlord. The landlord assumed that because it had spent this amount of money, and because it could raise, and it did its calculations, it decided it could take the apartment out of rent regulation, right?
And-
The DHR didn't say anything about it.
You're correct, Your Honor.
Yeah.
But if I may, there's never been a dispute that those monies were spent and the apartment would have been deregulated by virtue of the $2,000 threshold. That's not in dispute in the record. So if by law, once it went in excess of that $2,000, it was deregulated, and therefore the landlord couldn't offer preferential rent riders back in 2007, which also would have included a reference to legal regulated rent when that law didn't exist until 2014. And that's why I refer back to the Regina decision, because Regina decision in footnote 9, when they wanted to penalize the landlord for not.
Well, first of all, I have to stop you. Regina, you're referring to a footnote. That's not the holding in Regina, and Regina did not invalidate this regulation that's at issue here. And that's what DHCR applied. It's not irrational. It was a rational determination that this wasn't, what's the word I'm looking for? Punitive, here against the landlord. And so this decision is not irrational.
Okay, so first of all, in footnote 9, it wasn't a dicta holding. What it said was that what in footnote 9 of Regina specifically said you can't penalize the landlord.
Holdings don't exist in footnotes.
Even assuming that to be the case, the point being was that in the main holding of Regina, throughout the holding, it's still of the opinion that you can't punish the landlord for following the dictates for following the holdings of DHCR, okay, which ruled these type of apartments to be deregulated.
So isn't the question?
Okay.
Isn't the question whether there's prejudice to the landlord in applying this retroactively?
And I believe specifically there is, because the differential in the rent between the legal regulated rent and the preferential rent is $1,500 a month, so that's $18,000 a year. If you look at the Appellate Division decision in Starch, it found that would be prejudicial. And in fact, there was a holding by DHCR on this exact issue back in February 2020 in the Yackel decision, which we cited to in our brief. And the Yackel decision, the DHCR itself said, and this is the quote from the decision, "The commissioner finds it would be irrational to expect that when executing a vacancy lease, the owner would apply a law that does not exist. The commissioner finds that the waiver of the higher legal regulated rent in the subsequent leases results in undue harm to the owner."
Let's continue, counsel. I'm sorry that I asked you the question towards the end of your time. Perhaps we can continue this during your rebuttal time.
Thank you. Mr. Ambaras, is it?
Yes, thank you, Your Honor. Robert Ambaras, I'm of counsel to Mark F. Palomino, who is the counsel for the respondent, New York State Division of Housing and Community Renewal. So there are two interrelated issues here. The first issue is whether the claimed legal regulated rent was previously established. And in order to determine whether that claimed legal regulated rent was previously established, and that previously established requirement, that is not something that comes out of a regulation that DHCR promulgated, but that is in the rent stabilization law, in the provision in the 2003 amendment governing the determination of preferential rents upon renewal or vacancy. In order to exercise that option to terminate the preferential rent, the owner has to be able to demonstrate that that rent was previously established. DHCR has to be able to determine whether that rent was in fact previously established. That requires documentary evidence that the rent was actually in a lease, or that it was registered, and that the tenant had notice of it. And that is at bottom, that is a contractual requirement. As the Court of Appeals held in Century Operating Corporation, and this court held in Missionary Sisters, as a matter of this is the determination whether there was an agreement to a preferential rent and a higher legal regulated rent is a contractual determination. And so in order to make a rational and fair and rational determination of that issue, DHCR needs to be able to examine all pertinent evidence, and that evidence may include rental history that predates the base date. And I should note here that in this case, the appellant is also relying on pre-base date rental history, namely the notice of deregulation included that was executed in conjunction with the 2007 vacancy lease to prove the claimed legal regulated rent. So as in the Ador case from the Second Department, which we cited in our brief, where the Second Department held that a fair and rational adjudication of whether a landlord was entitled to claim a longevity allowance upon vacancy required an examination of pre-base date rental history to confirm the length of the previous tenant's occupancy. Here, such examination is required to confirm that the rent that the landlord claims is the legal regulated rent was in fact previously established as required by statute.
Were there any?
Yes.
You finish your thought. Yes.
Yes, Your Honor. And in this regard, to accept the appellant's contention that DHCR is not permitted to examine pre-base date rental history would require that any time that a landlord claims that there is a higher legal regulated rent, that DHCR or the courts are required to uncritically accept that claim. And this is analogous to the claim that the court.
Thank you. Do you have any? Are there any questions from the bench? Thank you.
Thank
you. Yes, Mr. Shipley.
Ms. Shipley, hi.
Ms. Shipley. I'm getting the Ms. and the Misters confused today.
Okay. Good afternoon, Your Honors. May it please the court. My name is Jordan Shipley. I'm from the New York Legal Assistance Group representing intervener respondent Victor Kim. It is our position that this court should uphold and affirm Judge Hagler's entirely correct November 12th, 2019 decision and order, which held that DHCR's determination of a rent overcharge by petitioner had a rational basis, did not cause undue harm or prejudice to petitioner, and properly established the subject department's base date rent. Judge Hagler correctly ruled that the lower court had no grounds on which to substitute its own judgment for that of DHCR. Courts have definitively held that so long as an agency's decision is not arbitrary or capricious and has a rational basis, courts must not second guess the agency's decision. In his decision, Judge Hagler specifically stated that unreasonableness, arbitrariness, or capriciousness on the part of DHCR was, quote, not supported by this record, end quote. Once a court.
Can I interrupt you a second? So I did a lot of searching using my phone and found footnote 9 in Regina. Okay. And I ask you what applicability, if any, and I don't know if you have footnote 9 available to you.
I don't have it available in front of me.
Yeah, but essentially counsel is challenging 2526-128 and 2527-7. 2526 is the one that provides for the look back period, an extended look back period where preferential rents are concerned. And 2527-7 says that the current version of the code can be applied, of the rent stabilization code can be applied unless, quote, undue hardship or prejudice results. What say you in this regard?
So I think I'll address counselor's reliance on Regina Metro first. So the Court of Appeals in Regina said that the decision only applies to the retroactive application of certain provisions of the HSTPA. So, and that law is just not an issue in this case. So his use of and reliance upon Regina is just completely wrong and should be rejected by this court. To discuss, so I think you said section 25, 27,
2526-128 and 2527-7. The first one deals with the look back period, that it can go beyond the 4-year period. And the second one says that the current version of the code can be applied unless there's undue prejudice.
Right. So section 2526.1, it plainly states that when you're establishing the terms and conditions of a preferential rent, which is what's happening here, you can look beyond the 4-year period preceding the filing of the complaint. It's pretty clear in its language. As for section 2527.7, it says that any changes to the code shall be applied to cases pending before the DHCR unless there's undue hardship or prejudice to the petitioner, to any party, I guess, in this case, the petitioner. Despite what petitioner says, there is no undue hardship here. Petitioner deregulated subject apartment in 2007, even though they were still receiving J51 tax benefits and weren't permitted to do so. They knowingly failed to provide the required preferential rent rider with Mr. Kim's 2007.
Council, the preferential rent is back then is pretty similar to the rollback rent, right?
I believe so. I'm not sure.
Any further questions? Okay.
Thank you.
Mr.
Winiarski,
you have 1 minute rebuttal.
Thank you, Your Honor. Justice Renwick, if I can just go back to the issue of the footnote issue, and I understand the court's concern as to the footnote issue, but Regina was not limited to that footnote, right? I think we can all agree that the court also held that you were to not review rent records beyond 4 years unless there's an indicia of fraud. And the instant matter.
Counsel, that was not retroactive, except as counsel has already stated, only certain sections. And this particular statute that is at play here was not addressed or reversed by Regina.
Understood and agreed with Your Honor that this specific section was not addressed, but the crux of the Regina decision is that you
not
have
retroactively. No, I understand what you're going to say, but no, not retroactively.
But you have the goal of the decision, which is that you only have to maintain records for 4 years and you can't go back beyond those 4 years. You have to look at the base date beyond up to 4 years, and you only go back if there's indicia of fraud. There is no dispute here that there's no indicia of fraud. So if the complaint was interposed in 2016, you go back to the base date 2012, and if you look at the leases and
Counsel, I have no dispute with you if the case came up in January 2020.
But Regina would say that you have to
understand your point. Saying it, repeating it is not going to change. I think we all understand the point you're making, and we will consider it very carefully and closely. Thank you all. Buyer versus buyer.
Yes, Your Honor. May it please the court. Todd Harrison for the appellant, Danny Zarninski-Bayer. This is an appeal from a motion to dismiss in the lower court, in which the lower court dismissed some counts and kept others, but limited the aspect of those remaining counts to assets held, to assets actually in New York. The lower court in that ruling erred in 3 different ways. The first one was as a matter of law. The lower court ruled that it could not adjudicate assets located outside of New York based on the court's analysis.
The assets, this is the agreement that Johnny and the sister were a part of. But Danny himself wasn't a part of that agreement, was he? He wasn't a party to that agreement.
No, he wasn't a party to that agreement. He was actually shut out. The parties came to
New York.
I think
he had an opportunity to be a party. I think he was there, and I think he voluntarily exempted himself from it. But either way, he wasn't a party to it.
No, but he did not voluntarily exempt himself from it. What happened was Danny, my client.
I think that's really a side issue. The fact is, he's not a party to it.
He was not a party to the Johnny Vivian agreement. That's correct.
Right.
He was affected by it because the Johnny Vivian agreement purported to divide worldwide assets, inherited assets around the world.
But the question is whether or not there's subject matter jurisdiction here over these assets that are all over the world.
Yes, correct. And we believe that the lower court mistakenly decided that by doing a surrogate court jurisdiction analysis. The lower court cited to Obregon, which cited the Surrogate Courts Procedures, which referenced the Surrogate Courts Procedures Act of 2006. And based on that and other treatises that analyzed the surrogate court's jurisdiction, the lower court decided that it did not have jurisdiction to adjudicate those assets outside of New York. But we're not in the surrogates court. This is not an ancillary estate action. This is a tort action that's been filed in New York because numerous tortious acts actually occurred in New York. The parties came to New York to mediate. Johnny lied repeatedly to my client, Danny, about what he was going to do in the course of that mediation.
Well, counsel, this is Judge Scarpula. Your claim doesn't arise out of that mediation. Your claim arose way before that, right? So if you have 30, if you're looking at long-arm jurisdiction for a transaction that occurred in New York and the claim arises out of that transaction, your claim doesn't arise out of that transaction. Your claim is that in 2006, when they did the exchange and when the sister went to the Delaware court, those things didn't happen in New York at all. And all of your claims arise out of those issues.
But there are a number of things that happened in New York that extend this, that allowed for the accrual to start much later on in 2016. There was
you can't accrue and then accrue. It accrues, right? And you can't base subject matter or personal jurisdiction on a transaction that isn't connected to your claims.
Well, the lower court did find and upheld the counts relating to tortious acts, finding that there were tortious acts carried out in New York. And the fraud scheme was—
But I think that's only for property that's in New York.
Right.
We're talking about property that's all over the world.
Right. And Gowan and other cases specifically, point out that for Supreme Court jurisdiction, once you have personal jurisdiction over the tortious act in New York Supreme Court does have jurisdiction over assets outside of New York that are related to those tortious acts. And Johnny coming to New York and specifically lying to my client about what he was doing and what he intended.
First of all, you're talking about personal jurisdiction over Johnny. Johnny is not a domiciliary. He doesn't reside in New York. He resides in Ecuador. So there is no personal jurisdiction over Johnny. Then you're talking about subject matter jurisdiction, I think, over the agreement. But he's not, the agreement doesn't apply to, as my colleague has said, 2006 or 2016. The agreement is separate from that. Your claims arose then and don't directly address the agreement.
Well, they include
your client's not a party to the agreement.
Our client is not a party to the agreement. That's right. He was shut out of the agreement when Johnny came to New York, and Johnny and Danny had the same lawyer.
So you keep going back to the same issue, and there's a basic problem here. Your client has no privity with respect to the 2016 agreement, which contained the forum selection clause. He cannot be a beneficiary of the forum selection clause because he was not in privity to that agreement. It's like A to B and B to A, and we can't change that, can we?
Well, I'm not saying that we should change it, but there were tortious acts committed in New York that were related to the Johnny Vivian agreement.
What are you talking about? That are related to what acts are you talking about?
So all of the parties came to New York, voluntarily came to New York, decided to come to New York to try and mediate their dispute. During the course of that, as we've laid out in our second amended complaint, Johnny made a series of lies and promises to my client Danny regarding that were continuing from the previous lies that he had told, but also involved
2006.
Yeah, since 2006, Johnny had been.
Isn't there a statute of limitations with that would have ended that? I mean, didn't he have, when he realized whatever it was in 2006 that he got preferred stock instead of common stock, or later on when he realized that, gee, Vivian had an idea when she decided to sue him in Delaware? Didn't all of that, wasn't your time at the first instance when your client should have known? I'm not you, but wasn't your client's action, didn't it accrue when he first should have realized all of that? Wasn't that back then?
No, because Johnny's lies continued throughout that whole period of time. He continually lied to Danny about what he was doing in the mediation negotiation.
Counsel, this is Judge Scarpula, but the fact that the lie continued, it's when does the cause of action accrue? And the cause of action accrues when the lie occurred, right? So you're saying that lie occurred in 2006. No, so I don't know how the fact that the lie, that's when he could have, that's when the injury occurred. And the fact that the injury occurred then means that the statute starts to run then. It's sort of like you're throwing everything into a ball, throwing against the wall and hoping that part of it sticks. But if you pull it apart, it doesn't.
Well, counsel, even if you go to the 2011 action that's commenced by Vivian in Delaware, and even if you said my client was blindsided and knew nothing about anything that was going on, aren't you still in trouble? Because you have to refer back to 2006, and the 2011 would probably add you 2 years. 2 years being 2013. But this action is commenced, I believe, in 2018. So no matter how you dice and slice, you end up with the same problem. The statute of limitations has expired, hasn't it?
No, I disagree. So our action was started in November in 2016, which is the first time that my client Danny realized that Johnny had been lying to him that whole time and defrauding him about what was going on with the assets of El Rosado. He didn't know it before that. Johnny had continually lied to my client about what Johnny was doing with the assets of El Rosado, and that lying to my client saying that don't worry about any of these court actions, I will take care of them and I will make sure that you get what you deserve, your 1/3 shares in Rosado and everything else in the estate. Those were
so I'm going to pause then. We've gone over time. You can, let's hear from Mr. Briggs. You have 2 minutes rebuttal.
Thank you, Your Honors. May it please
Why don't we pick up from where counsel has just left off? He says his client only realized this when the 2016, I believe it was.
Let me say that Danny has admitted in litigation in Israel that he received 1/3 of El Rosado's stock in 2006 and has been aware since then he did not receive the voting stock he thought he was entitled to. So since then, he's been aware of all of the underlying facts that gave rise to his claim. Even setting that side of fact
he's saying that Johnny was very good at pulling the wool over his eyes. So maybe he knew it, but then I guess Johnny persuaded him that what he thought he knew wasn't accurate or something. I'm not quite sure, that he would make it up somehow.
Yeah, I don't quite follow their argument either, Your Honors, because certainly by 2011, when Vivian alleged the exact same scheme in Delaware, including that she had relied on Johnny's promises, Danny was at a minimum on inquiry notice that he should do more to preserve his claim and investigate the facts. But I don't think there's any question that he was actually aware of all of the facts that gave rise to his claim by 2006, at the latest by 2008, when the alleged 5-part scheme was concluded upon the transfer of the assets outside of Ecuador into BVI companies. I think there are a number of independent reasons why the motion court was right to dismiss the claims concerning El Rosado. But in certain respects, they all dovetail together. At the most basic level, whether Danny has some personal claim or inheritance claim is not an issue that has any connection to New York, whether through application of New York law or as a matter of fact. At heart, the claims concern the estates of his parents, who never lived in New York and held only nominal property in New York. Their estates have already been the subject of estate proceedings in Ecuador and Israel. This is but Danny's latest attempt to find a forum to litigate claims that were already raised by Vivian and rejected in Ecuador, and later rejected by the Delaware court when Danny switched sides after 5 years disputing Vivian's identical claims. I think an important point to note is that in 2011, when Vivian filed her claim in Delaware, Danny actually disputed that claim for 5 years. Danny retained DLA Piper to defend him against those claims. And only in 2016, when he decided not to participate in the settlement because he didn't like the terms, did he switch sides in order to try to extract leverage. So here, where there is no connection between New York and the claims or the defendant, where other courts have already addressed these claims and determined the scope of the parents' estates as they relate to El Rosado, where the parents were not domiciled in New York, and where not only did Danny sit on his rights for 10 years, but actively opposed the very same claims he brings when brought by his sister, the motion court rightly determined that claims should be dismissed and based on notions of comity should decline to take jurisdiction over estate assets beyond its territorial borders. Whether in a different...
Oh, I thought
No, that's fine, Your Honor. I think I've covered all of the main points that I wanted to cover today.
Thank you. We're back to you, Mr. Harrison.
Thank you, Your Honor. So just a couple points. When because it's been brought up, when Vivian filed her claim in 2011, as we lay out in the complaint, Danny went to Johnny, and Johnny told him, Vivian's complaint is untrue. It's a lie. Join with me to fight against Vivian and her lies, and we will overcome Vivian together, and then I will make sure that you are made whole and that you get everything that you deserve. And that's in the complaint at paragraph 89. And you sort of start to see how every step along the way, Johnny led Danny around by the nose and lied to him repeatedly about what Danny had done, which was siphoning off all of the assets of El Rosado into other entities that he controlled.
But counsel, if I may, you're not talking about someone who's incapacitated in some way. You're talking about someone who chose to believe his brother as opposed to his sister. I mean, isn't that where we end up here?
I don't think that's the full story.
There's nothing in writing to back up what you're saying either.
Well, I don't think that's the full story, Your Honor. Johnny is Danny's older brother. Danny has a long history of sort of believing Johnny and being led around by the nose by Johnny. And that doesn't excuse Johnny's continual lies and defrauding of Danny because he did that.
But it also doesn't excuse Danny's not using just the common sense. When you are not sure of something, and as my colleague said, it's the difference between your brother and the sister, maybe then it's time to get legal advice at that point.
Well, but I don't think we can hold it against someone that they didn't go get legal advice because they disbelieved what their brother was telling them. The brother,
There's no exception in the law for believing your brother.
That's exactly what you have to do.
The older brother also being the president.
You have to go and get some, you have to do something when you're on inquiry advice. Can't hold up your hands and say, I'm not going to investigate it because it's a family member. In that event, every family corporation would never have a statute of limitations for fraud or any other tort claim.
Sorry, not only was it his brother, but Johnny was also in charge of all the El Rosado entities and control of that information. In addition, Danny did try and go or thought he was going to get legal advice from an attorney, but he allowed Danny, his older brother, to hire the attorney. That attorney then acted in Johnny's interest, not Danny's interest, in the mediation in New York. And that attorney ended up having to withdraw from the case once he realized that that there was a conflict of interest, that in fact, what Johnny had been telling that attorney was not true. And that what Johnny had been directing that attorney to do in the mediation that led up to the Johnny-Vivian agreement was absolutely not true. That attorney had to withdraw because he wasn't representing Danny's interest when Danny thought that Johnny, his brother, and the attorney were representing his interest, and they simply weren't. And that's proven by the fact that that attorney had to actually withdraw. And that just shows you the lengths that Johnny went to lie to his brother, to my client, and shows you that the attorney finally at the end recognized that. But those negotiations were the basis for what led up to those false, I would say, negotiations were what led up to the Johnny-Vivian agreement that was negotiated and signed in New York that divided up all of the worldwide assets between Johnny and Vivian. And it wasn't because Danny didn't want to take part. Danny desperately wanted to take part. He thought he was taking part, but Johnny had been directing their joint attorney that Danny thought was representing him and telling him to represent only Johnny's interests. So that's really not fair to hold
very
against.
much. Thank you. Thank you very much. I've given you extra time. Thank you both.
Thank you, Your Honor.
Board of Managers versus of the San Tropez Condominium versus JMA Consultants.
Good afternoon, Your Honors. This is Salvatore Gianpiccolo. May I begin? Proceed?
Yes, please. Thank you.
Thank you, Your Honors. This is Salvatore Gianpiccolo of the firm of Stevens and Lee, and it is respectfully submitted that the court below erred in not granting the dismissal of counts 4, 5, and 6 of the based on the bar of the economic loss rule. The key question here, Your Honors, is whether plaintiff has a cause of action in negligence. And
Sir, I'm having a really hard time understanding you.
There, there might be some other microphones open. Unless you're speaking, keep your microphone off, please. Thank you.
And keep your face up so we can see hear you better, please.
Yeah, my head is up here. Okay.
He's up. He is up.
Are you still having a problem hearing me? Or
no. You having a problem, Justice Gonzalez?
Yeah, I see her flinching. I could see her.
Yeah, he's coming across so fuzzy. So
okay, I think maybe it's something on your end. If you would continue, Mr. Gianpiccolo.
Gianpiccolo, Your Honor.
Piccolo.
It's a short Irish name, Your Honors.
Piccolo, like the instrument. Okay.
That's correct. Yes. So the key question here, Your Honors, is whether plaintiff has a cause of action in negligence. I assert that they do not. All of the causes of action and allegations arise out of the 4 contracts that were executed by and between the parties. There is no independent duty that pled or that actually exists here. And it's important to note here, the New York courts.
What about the cases that discussed abrupt or catastrophic consequences, given that this building, half of it, whatever the top of it, fell over?
Great point, Your Honor. And that's what the lower court relied on as trustees of Columbia. That decision is inapplicable, and there's a huge distinction between those 2 cases, which is the trustee of Columbia, as well as 729 Broadway, Your Honor, Broadway Group. Those are what is being relied on by the respondent. The key here is we don't have a design build project here. We do not have a design. We have a engineering company that came in to do survey work on a pre-existing building that's 50 years old. And this was not abrupt, catastrophic occurrence. This was gradual. This was happening over years of neglect and lack of maintenance by the building. In fact, our client, the appellant, JMA, actually went out there, did the survey on June 30th, 2014. And they were only to do the survey. They were not doing the actual probes or inspections. That would be done at a later time once a contractor was selected and actually scaffolding put up on this building. In fact,
and whose determination was that?
That was at the building. That's the respondents. That had nothing to do with JMA, Your Honor.
Counsel, weren't you free to request a probe? Weren't you free to request additional diagnostics of the building, so to speak? Looking at the scheme, how do you call this? The plan that you made?
Yeah, the survey.
Where it says number 9 probe possible, and then you look at the legend and it says number 9 movement, wall movement. Did you or did you not have an obligation to highlight that and alert the condo board that it needed to have additional, I'm calling it diagnostics because I'm thinking of medical, but that's not the right word.
The survey, you're talking about the actual probe itself, the actual inspections were contemplated to be done once they're scaffolding. The building did not want to put up scaffolding separate and apart than actually when the work is actually being done. So let me just, the timeline is so important on this so that you understand that this is not an abrupt catastrophic occurrence as alleged by both the lower court as well as the respondent. The important part here is that on June 30th, 2014 is when that survey report was done. The building did not contract with the QBC, which is the contractor, until August 3rd, 2015. The third agreement between JMA and the respondent actually was for the bid process, and that was done in July 2014. So a large time frame went by between the actual survey conducted and when the actual building actually retained the contractor QBC. And in fact, under the QBC contract, the building did not want to do the work on that side. They just specifically wanted the work to be done around the pool so that the pool may be open during the summer season. So the contractor did not put scaffolding on the southern side of the building where the failure occurred, not until December 4th. That was 3 days before the collapse on that side of the building. And
did you have an obligation to inform the condo board as to what the dangers were?
Your Honor,
where wall movement is detected?
Your Honor, whenever there's wall movement, it's always detected. You have to go in and do probes and inspections. If the building's not willing to do and put up scaffolding, there's no way for the survey company who is doing the survey and envelope of the building can do it. In fact, Your Honor, what's important is the contract actually specifies that there's going to be hidden and unknown conditions. It clearly provides for that. And if I may, the contract on page 4, which is of the general contract, the owner understands and agrees that the repair work is being performed upon an existing building and with possible hidden conditions, and that work, in addition to the work described in the specifications and reports, may bear required based on unforeseen and or unforeseeable field conditions. Here.
Thank you. On that note, let's move to counsel. Mr. Juneau? No.
Yes, may it please the court, Thomas Juneau from Armstrong Teasdale, yes. Representing respondent board of managers of the Saint-Tropez condominium. The trial.
Why shouldn't this just be a contract action?
Well, because of the nature of the damages here, Your Honor, in a contract
action. But the nature of the damages, you have 4 different contracts, and the contract clearly is controlled by you. You hired these people, you asked them to do the survey, and you told them only look for, they're supposed to look at the building facade and bulkheads and areas of water penetration reported by the owner, you. So that's where they're supposed to be looking at those areas. Then the survey is supposed to be based on visual inspections without invasive probing. You've indicated there are possible hidden conditions that based on unforeseen field conditions. Council has, those are the things in the contract. Council has just indicated that you asked to begin work on the other side so that the pool could be opened. Why, this is not an instance where this contractor designed, was the architect for, built the structure that then fell. And unless council's wrong, in June is when they inspected. The report was in 2014, and then a year later, you hire them. You don't even hire them for an entire year, and the facade doesn't fall until even sometime thereafter. Is that?
Your Honor, this is, first of all, this is in the context of a pre-answer motion to dismiss, and the contract that the board entered into with JMA extended over some period of time. That is true, but the JMA was hired to provide critical observation of of existing conditions.
Observation.
To report and to recommend priority issues, among other things. And they did not do that properly. And this is not a case where it's just simply breach of contract damages, because the Court of Appeals has stated that negligence does not attempt to afford the injured party the benefit of any bargain, but rather endeavors to place the injured party in the position he or she occupied prior to the injury. Damages in a negligence claim seek to make the injured party whole. The type of injuries compensable.
Except that this has to fall into the category that is permissible under the case law for cases like this, and this one is distinguishable because of the things I've just said.
No, this case
isn't it?
No, Your Honor. I think this case falls right under trustees of Columbia University and falls within the ambit of.
So the architect who built the wall is the contractor here who reviewed it. Is that what you're saying?
No, I'm saying.
Because there was an architect in the Columbia case. The architect gave all the specifications and I think was involved clearly in building the structure, and then it promptly fell.
Well, 10 years later, but yes, it did fall.
I don't think that's supposed to happen.
No, it's not supposed to happen, but we retained JMA to provide.
How old is this building?
I think it was built in 1964 or 5, Your Honor.
Okay, so it's 60 years old or so, approximately.
Right, and it's existed.
You want to talk with me or you want to wait for me? Okay, so it's about 60 years old, and you call them for inspection and then waited over a year to make a determination as to who you would hire.
Well, we did that. We retained them more for doing an inspection, Your Honor. There was a long list of things that JMA was obligated to do, which was to report, recommend priority issues, among other things.
So, counsel, if I may.
Yes.
So I looked at the complaint and I looked to see with what specificity you indicated, you differentiated the breach of contract claim from the negligence claim. And what you're saying is that the report provided to you was incomplete. The notice provided to you with respect to the wall movement was incomplete, because I don't see that. I don't see that in the complaint. And is that a problem or is that not a problem?
Well, the problem is that JMA, among other things, was required to inform us. The board is composed of laypersons who hire JMA for their expertise.
That's a given.
Right, and so we look to them to advise us as to what should be done first. What work should be prioritized, and in fact.
So counsel, if I may. Were you told what was to be done stage by stage? And is counsel, your adversary, incorrect in saying that even though the information, and I'm putting this out there, I'm not saying that they did, are they saying we put the information out to you, the southern exposure needs to be done first, there's wall movement is inherently dangerous, it needs a probe ASAP. Are you saying that happened? Because
No.
I didn't see it in the complaint. And
I think the answer was no. Is that right?
No, the answer, we were not told to prioritize the southern facade because of the wall movement at all. And that's part of the problem here. We retained JMA in order to advise us about the entire, and this was a large project. This was various facades. It was a terrace and roof restoration project, and we retained them to advise us as to what work to do and the priority in which to do it. And they failed to do that. And
so, counsel, isn't
further questions?
That's a straight up breach of contract, right? What other duty do they have to you other than a breach of contract duty? They don't. And that one case that makes an exception to that is when a fire could break out and the public itself could immediately have been burned to the ground. And so there's a tiny little sliver. But the general rule is, and always has been, that the only duty that arises is a contractual duty, and you have a remedy, which is breach of contract. They were supposed to do that, you say, and they didn't, and they breached. And that is the general rule, has been the general rule for a long period of time. So unless you're trying to put yourself in that tiny little sliver that isn't the general rule.
But Your Honor, the distinction factor here is that we have professional liability here, that where the cases have found a negligence claim does lie, and particularly here with the type of injury, because the type of injury compensable in negligence are personal injuries and property damage, and thankfully there wasn't any personal injury. But
I think we have your point. I've let you go over time. Thank you very much. Mr. GM Piccolo, you did not ask for rebuttal, so you are both done. Thank you both.
Thank you, Your Honors.
Thank you, Your Honor.
Michael Melaku versus AGA 15th Street. Mr.
Good
Shapiro?
afternoon. I am here. Can you see
Yes,
me and hear me?
you may begin. Yes.
Thank you. Thank you. Good afternoon. May it please the court. My name is Sim Shapiro from the law firm of Baxter, Smith and Shapiro on behalf of the defendants, appellants, respondents. I realize I have a brief amount of time and the court has in fact reviewed my brief. So I want to just point to just a couple of very quick items. They're clearly in this case, I'm sorry, just you can see me a little bit better now. There clearly in this case is a very significant divergence into what was available to this plaintiff and in fact what he did at the time of the incident. The plaintiff has denied a pulley system. There's clear sworn testimony from one of his coworkers that there was a pulley system, and in fact, he didn't know why he hadn't used it. Above and beyond that, there was also a contradiction in terms of what the plaintiff could have used. There was clearly sworn testimony from two of his plaintiff's coworkers that he was really supposed to have used the ladder on the side of the scaffold as opposed to this A-frame that nobody had directed him to use. And I think that's critical because under Montgomery, the standard is a logical response. And here, a normal logical response would have to have been used to use the pulley and not been on any ladder at all. Above and beyond that, to have used the other ladder. And respectfully to the court below, there seemed to be a misunderstanding in terms of what his supervisor had said was dangerous. In fact, it was a supervisor, Mr. Pereira, who testified that in fact, he should not have been using that A-frame ladder. He should have been, in fact.
Counsel, this is Judge Gonzalez. So wasn't the ladder that was built into the scaffold supposed to be used with a harness? And weren't those two harnesses in use at the time?
There's testimony to that effect, but again, he shouldn't have been on the ladder at all. He should have been using the pulley system. And I understand that the plaintiff's testimony on this is very simple, which is, oh, I don't know about any pulley system. That's an issue of fact. That's not a case to grant summary judgment on. And in fact, I want to point out something that wasn't seem to be the focus of the court below so much. The plaintiff's own testimony here about what he was doing and where he was at the time. If you look at page 330, he contradicts himself or seems confused about what he was doing. On page 330, if you look at that, page 330 of the record, when he was asked, were you ascending or descending? He said on line 23 there, I was descending it. There was actually the plaintiff's position in his brief and elsewhere has been he was ascending it and was about to grab this bandsaw. Above and beyond that, the plaintiff then says a few pages later on page 337, he seemed to be very confused as to what he was doing at the time. So the question was, had you retrieved the bandsaw when you had your accident? Answer, no, I went to, and there's dashes there in the testimony, it's clear he hesitated. I attempted to retrieve it. And then again, another question. So you had yet to lay your hands on the bandsaw when you had your accident. Is that correct? Answer, and again, there's hesitation. There's clearly from the dashes in the transcript. I can't recall exactly. No, I don't think so. So this is a plaintiff.
You finish up your
Okay.
sentence.
Yes.
Okay, all right, you have some rebuttal. All right,
Thank you.
Mr. Feinberg? Mr. Feinberg, you're muted.
Hi, good afternoon, Your Honor. I join in Mr. Shapiro's argument that the pulley system was available and echo the point that Mr. Melicu's coworker indicated that the pulley system was available for a few days, that Mr. Melicu used it prior to the incident. And there was an expectation that if materials needed to be transported from the floor up to the top of the scaffold, that the workers were supposed to use the pulley system. And specifically looking at the legal flaws of the decision below, the trial court imposed a requirement that is not set forth in the controlling standard of Gallagher versus New York Post. In that case, the Court of Appeals held that the sole proximate cause defense applies when the safety devices that a plaintiff alleges were absent were readily available at the work site, I believe not in the immediate vicinity of the accident, and the plaintiff knew he was expected to use them, but for no good reason chose not to do so, causing the accident. So under this standard, there's 3 different conditions that need to be met. First, safety devices are readily available at the work site. 2, the plaintiff knew that he was expected to use these safety devices available, but unreasonably chose to do so. And 3, plaintiff's choice not to do so resulted in the accident. That's exactly what happened here. And according to Frederick
Counsel,
Munoz,
sorry, didn't the plaintiff testify that there was no pulley system in effect, and didn't I don't know if it's Mr. or Ms. Pereira testify that he didn't know if there was one in use when the plaintiff was working that day?
Yeah,
you're referencing a pulley system.
Yes.
Where does it say that there was one that was operative that day?
So Mr. Munoz, who I was referring to, he was one of the co-workers who was working on the 3rd floor of the auditorium that day, was working with Mr. Melicu, and he was actually working on the top platform of the scaffold. And he testified that at the time of the accident, there was the pulley system available. With regards to Mr. Pereira was the foreman who wasn't stationed on the 3rd floor, so he didn't have any actual personal knowledge as to exactly what was going on the 3rd floor. So he couldn't say one way or the other whether a pulley system was in use. And as Mr. Shapiro indicated before, yes, Mr. Melicu denies that there was a pulley system, but just as Mr. Shapiro said, that creates the issue of fact right there, especially when you view that in context of the legal standard where you have a reasonable safety device available and there's an expectation that they're supposed to use it. And that's exactly what Frederick Munoz testified to at his deposition. So under
well,
the
Mr. Feinberg, let me just interrupt you. Isn't it that you're told to use it and you don't? Isn't that the standard?
that's what
the standard, right?
That's not the standard, Your Honor.
Well, okay.
The lower court.
I think there are lots of cases that say that. So
there may be cases that say that, but if you actually
was
look,
he ever told to use it and he decided not to?
there's no evidence that he was told to use it, but there was a reasonable expectation that he was supposed to use it. And if you actually review the standard in Gallagher, there's no requirement in Gallagher that says that this defense only applies if a plaintiff is directed to use a specific safety device. That's those courts that have held otherwise. Those courts' decisions, respectfully, are inconsistent with Gallagher, and Gallagher.
So all of our First Department cases that say that are all wrong?
I'm not. I mean,
that's basically what you're saying, right?
Those facts
are all wrong. That Gallagher doesn't require it. They're all wrong.
I'm saying that there's a
if someone would expect that you would use that and he didn't, that's the end. That's an issue of fact.
Well,
I don't think the First Department has said that.
The First Department hasn't said that, but the First Department respectfully has overread Gallagher in imposing a requirement that Gallagher does not say. If you look at just the standard.
Thank you, counsel. I think we have your point.
Okay.
Thank you. We're on to Mr. Herrickman.
Thank you, Your Honor. First of all, good afternoon, Your Honor. counsel is making this case sound like something it isn't. First of all, what this case is a man, first of all, who had to take a saw that wasn't on the ground and put it in a bucket and bring it up. It was 2 levels up above him, between him and his senior workers who were 2 levels above him. So the first thing that he had to do, even if there were a bucket and a rope that were available, there was no pulley system. Nobody said anything about a pulley system. It was merely a bucket and a rope. But in order for him to get that saw into the bucket, he had to get it off the 2nd level, which was 12 feet off the ground. So he did what a normal person would do. He took a ladder, he took a 12-foot ladder, put it next to the scaffold, climbed up to the 9th step, and while he was reaching for the saw, he lost his balance and fell. That is a prima facie violation of Labor Law 240. A ladder did not remain erect. After that, they have to prove that he was instead the sole proximate cause, and he can never be the sole proximate cause when the failure of the ladder was a proximate cause, which it was. And by the way, there's one expert in this case, and it comes from one of the defendants, and in that, at paragraph 22 and 26 of her affidavit, she said that a ladder was a perfectly suitable device for doing the work that he was trying to accomplish, which was to retrieve the bandsaw from the 2nd level to get it for his workers. Nobody has ever, none of the defendants have ever met with that argument and explained how is he supposed to get the saw from 2 levels up, down into the bucket, and then back up without getting up there first to get the saw.
Thank you very much. Mr. Shapiro, you have 1 minute.
I do, Your Honor, and I'll speak quickly.
Good.
To address what was discussed just a moment ago with my colleague, Mr. Feinberg, I think what was being discussed by the court was somewhat more nuanced and a little bit different than what we're talking about here. That would be in the context of a recalcitrant worker. What we have here is a different standard under Montgomery, which is a normal logical response. That continues to be the law in New York, and I know in the First Department as well. The issue here is not that the plaintiff had
the issue here is that he was on a ladder. The issue here is he was on a ladder. The ladder wasn't secured, and he fell off of the ladder. We have plenty of these cases.
I understand, but when he's not supposed to be using that ladder at all, and is supposed to be using, you could call it a pulley system.
He was not on the level where there was the ladder that was adhered to the what do you call it? The scaffold.
There was testimony that he absolutely could have used it, and there was testimony that he could have used the pulley system. If you want to call it something else, you want to call it a rope and bucket.
Yes, but as counsel has indicated, he had to get the thing. That's why they asked him to get the saw. In any case, we have your point. I thank you very much. Time is up.
Thank you.
Thank you, all 3 of you. Thank you very much. In the matter of the application of Francine Bryant versus, New York City Housing Authority. Bryant versus Garcia?
Yes, Your Honor.
If you would begin.
Thank you, Your Honors. I am Teresa DeFonso of Counsel to Legal Aid Society representing Francine Bryant. The termination of Ms. Bryant's tenancy and her subsequent eviction is a punishment that is wholly disproportionate to the events that occurred. In attempting to justify this most extreme punishment that NYCHA can mete out, NYCHA argues that Ms. Bryant is a continuing danger to the NYCHA community. Nothing could be farther from the truth or farther from reality. Ms. Bryant is a 64-year-old woman who has lived for over 40 years in her apartment without any incident at all. It is clear that this incident could not have been more out of character for Ms. Bryant, and there is no likelihood that it will be repeated. Ms. Bryant was suffering a severe emotional strain caused by the fact that she had a breakup with her long-term partner who had engaged in an affair with a NYCHA employee. After this affair was discovered, this NYCHA employee continued to harass and insult Ms. Bryant as she simply tried to go about her daily life.
Counsel, in looking at, this is Judge Gonzalez, in looking at the transcript, I didn't see a timeline as to when the initial discovery was made or when the taunting happened, relative to the date when the petitioner went behind, hit the worker from behind. So is that relevant, or is that not dispositive here?
I don't believe it's dispositive, Your Honor, but I think the testimony does indicate, though I do believe it's not specific, but I believe it indicates clearly that the taunting and harassment was an ongoing issue that was continuing to occur. It hadn't stopped sometime in the past, and then Ms. Bryant reacted, weeks or months later. This was a continuing.
We don't know from the record, right?
I think the indication is do not have an exact date.
I'm sorry, say that again?
Do not have an exact date testified to. That is correct, Your Honor. But I think it's clear from the record and from Ms. Bryant's testimony that this was an ongoing issue that she was suffering from and dealing with at the time she snapped and struck the NYCHA employee.
Any further questions? Did you have anything further, counsel?
Yes, I just wanted to say that this court specifically in 2014 in Rock versus Rhea said that, and referring to numerous cases that I decided in the past, said that where the conduct is isolated or specifically related to circumstances that give some explanation of why it occurred, the termination is inappropriate. And I want to just emphasize the word explanation, because NYCHA in their brief and in their argument below argues that Ms. Bryant is trying to justify her behavior. She is in no way trying to justify her behavior. She is in no way asking this court to approve of it or say that it is acceptable. She is simply asking this court to understand that she made a one-time mistake that has no likelihood of reoccurring, and she should not be penalized by the loss of her home, which will have ramifications for the rest of her life for herself and her daughter, who is entirely blameless in this matter.
Thank you very much. Mr. Lupin, is it? Yes.
Yes. May it please the court, Andrew Lupin for the respondent, New York City Housing Authority. There's nothing shocking about the Housing Authority's decision to terminate the tenancy of an individual who physically assaulted a Housing Authority employee on development grounds while she was doing her job. The Housing Authority needs to ensure.
Counsel, this person, this individual, the tenant, has lived in that building for 40 years. Have there been any complaints?
There's nothing on the record beyond this.
Well, if there's nothing on the record, then you have no complaints. Isn't that right?
Well,
do you have any complaints is the question.
I am unaware of any other complaints. She was charged with.
Okay, so then this woman has lived for 40 years. She's raised her daughter. She's lived in these projects. She's had no complaints from anyone of bothering anyone. And I'm sure you investigated this very well. You could have spoken to neighbors and others. You would have gotten information that she had assaulted or had behaved in some manner that was inappropriate. No, nothing illegal, nothing physical, nothing. And for 40 years in that way, this one incident based on a woman who went in, I think that she is the tenant of record along with her daughter. I don't think the gentleman was a tenant in the apartment. And this employee that you speak about went into her home, into her bed, had relations with this man, left part of her clothing there. None of that was challenged at the hearing. Is not disciplined at all. And this woman, she was wrong, and she admits that she was wrong. She acted out and physically assaulted the woman who slept in her bed and entered her apartment unbeknownst to her without her permission. And for that one instance, she's going to be tossed out of her building? That shocks my conscience. I'm sorry.
All right.
Well, I've considered this. I've looked at it. I speak for myself.
I don't believe that the tenant of record's belief, this is her testimony, that this is what she believed had occurred.
It was not challenged. There was opportunity. The other individuals, the employee of the housing development testified. This was not challenged.
And petitioner's counsel did not cross-examine the employee about
Well,
these
then that's what we have. That's the testimony of the hearing.
And the hearing officer considered that that was the belief of the tenant, but concluded that it does not justify a physical assault.
It was to determine facts. The facts that the tenant testified were not challenged. There was an opportunity through other witnesses. In fact, the other witness that was the complaining witness. It could have been challenged and it wasn't. So those are the facts we have. It's not merely her belief, is it?
Regardless,
we have to conclude that's what it was. At this point, there was nothing to challenge it in any way.
I don't think she had firsthand knowledge of anything. Her testimony was that both her ex-boyfriend as well as the employee denied that there was an affair. So she speculated. At the hearing, that was her testimony, that this was her belief that this occurred, and that she had found underwear in her apartment.
At the hearing, there was nothing. She said that this had happened and nobody challenged it, counsel. Do you have anything else? Do you have anything else?
I think we have. Well, counsel, I do have a question to follow. Assuming, I looked at the record as well, I don't see that it was challenged. However, assuming it was not true, again, she's been in the development for 40 years. I believe the reason that you're undertaking this penalty is because of fear for safety of the NYCHA employees, fear for safety of fellow tenants. Is that correct?
That is certainly an element. My
point is, as Justice Renwick mentioned, this tenant has never engaged in this type of behavior in the past, and I am not stating that I'm not stating that it wasn't violent.
You're not condoning it.
I'm not condoning it, but she's never engaged in any other conduct. The NYCHA employee who was the complainant or victim has been transferred. There's nothing to indicate that she petitioner would be, engaging in this type of conduct with any other NYCHA employee or any other tenant within that building. So then why, again, would eviction be the proper penalty?
Well, I think that we need to consider the fact that the employee was actually seriously injured. She had to go to the hospital after the assault. She was bleeding from her nose. She was not able to work for several months after the assault because she suffered a slip disc and back pain, which prevented her from working as a caretaker.
As I said, I'm not condoning the action. I'm not stating that the employee was not injured. I'm looking at it going forward. That employee is no longer that NYCHA development. So again, if we're looking at this petitioner, which is like what we should be looking at, why is it that eviction would be the proper penalty, given the fact that there's nothing in the record that I saw that in any way suggests that she would be, again, a menace to other NYCHA employees or to tenants within the development.
Right. I don't think that the housing authority needs to wait for a tenant to assault someone a second time.
She hasn't assaulted anyone in 40 years. So now you're stating that now she's going to start assaulting everyone, other NYCHA employees who she believes is having an affair with her boyfriend or other tenants. I mean, don't we look at her record? Don't we look at her past? And there's nothing in her past. And I'm assuming that what you could do is put her on probation or have her as a probationary tenant, and then if she did in fact engage in this conduct, she would be evicted.
Well, I think the housing authority, it's a landlord and it's also an employer, and it has an obligation to ensure that its staff can provide essential services to its tenants without fear of being attacked. And it needs
to also— You're absolutely right. You're absolutely right. I think we understand. I don't know. I hope you understand the position that Justice Weber said. And by the way, while it is not the primary point here by any means, this NYCHA employee went into this woman's house without permission, her permission. I don't think there's anything that challenges that, unless, we're going to pretend that that didn't occur. But I think we get your point. Thank you very much. Ms. DeFonso?
Yes, I just want to point out one thing and make one other statement. Mr. Lupin said that both the boyfriend and the employee denied the affair. But the testimony was, and I believe I'm correct, that they initially denied it, as you would if you were having an affair, but then admitted it. And the employee was open about the fact that it had occurred in her subsequent actions of taunting Miss Bryant. And I simply want to say that I think the court is absolutely right that a probationary determination would be much more proportional to what actually occurred in this situation. And
that's not what I was saying. I wasn't suggesting that would be the penalty. I was just stating that in reference to counselor's statement that you don't know that this is going to occur again. I was simply stating that I would think that probation would be a possible response, but in no way am I stating that should be the penalty in this case.
Our role is only to determine whether it's arbitrary or shocks the conscience.
Can I ask a question, please? I just want to know, is that true? I didn't focus on this. Is it true that the employee was out for several months because of the injury that was caused by this assault?
There was no testimony there was no medical evidence.
Well, counsel, there was a letter.
A doctor's letter.
Counsel, yes. There was a letter, and it wasn't the authentication is a little different from what we would have at trial, but the letter from the spinal specialist included a diagnosis of cervical sprain, cervical nerve root impingement, and a lumbar disc radiation with radiculopathy. Yes. So that she was hit with the NYCHA worker was hit with a closed fist, not an open hand, but a closed fist, and that caused a laceration. So there is testimony, or that, not testimony, but there was evidence that was introduced, right?
Yes, there was, Your Honor. The only thing I was going to point out about the letter is that it recites that the employee said, the reason I'm suffering from these things is because of this incident. And that is not something the doctor, of course, could know. I'm not questioning all the doctor's diagnosis. The doctor's diagnosis speaks for itself. But the letter says, this person told me that these things are the result of this incident that occurred. So the cause and effect of the two things is what I'm saying. There was no direct medical evidence of.
Right. But these were symptoms diagnosed in a 28-year-old, right?
I believe so, Your Honor.
Thank you. Thank you both.
Thank you, Your Honor.
John Castronovo versus Dentsply Sirona.
I'm going to leave.
Yes, Justice Scarpullo is recused and Justice Manzanet is vouched in on this case.
Your Honor, William Frederick for the appellant. I'd like to reserve 2 minutes.
If you would just wait a minute, please. I just want to make sure that Justice Manzanet.
I'm here.
Thank you. Okay, you may continue. You may begin.
Thank you, Your Honor. I'd like to reserve 2 minutes of rebuttal. The complaint in this matter should have been.
You have 2 minutes for rebuttal.
Thank you, Your Honor.
Yes.
We appeal from 2 orders. One dismissing the complaint, which we submit was error, and one denying a subsequent request to vacate the judgment and allow repleting. Let me address first the motion to dismiss and the 32A11 motion. The prospectus in this case was false and misleading in at least 2 different respects. First, it out and out made a false statement that the market for dental supplies was highly competitive and omitted to disclose the fact that this meant that going forward, once that anti-competitive scheme was exposed, that this would mean that the combined company would have reduced profits because it would no longer be able to benefit from inflated prices as a result of the anti-competitive scheme in the dental products market. The court below dismissed the case primarily on grounds of puffery and a rule that really doesn't exist at law. First, the court said that competitiveness, or saying the market's highly competitive, is puffery. But puffery only applies when someone makes a statement that's not objectively verifiable, like, I make great cars or something like that, which would be common puffery in a commercial
Counsel,
context.
with regard to this, it was the plaintiff was a stockholder of Sharona stock. Am I correct?
That is correct.
And it was discovered that the Sharona stock, this was really it was suggested that it was a merger, but it was really more of a takeover by Dentsply of Sharona and an acquisition by Dentsply of Sharona. And the Sharona stock were actually much lower than anyone understood at the time of the acquisition. Isn't that right? So you're making allegations and these suggestions. I think that the court understood that and was really asking where the issue was here.
Yeah, Your Honor, this is an important point to clarify. It was a merger of equals. Two dental supply companies, one Sharona, one Dentsply.
Okay, was the stock equal? Was the value of the stock equal?
They were a merger of equals. There was an exchange ratio that was agreed to in the merger agreement.
So I didn't get it. Was that a yes or a no as back to the value of the stock?
It was a stock for stock transaction. I believe that Dentsply had a somewhat higher market cap at the time of the transaction than Sharona did, but it was a stock for stock acquisition. The value of the stock at the time of acquisition.
And Sharona shareholders received 1.8142 shares of Dentsply stock, the stock that was higher than its own stock. What was the stock value at that time?
I don't know precisely what the value of Dentsply stock or Sharona stock was. Sharona stock ceased to exist at the time of the merger. But if I can make the fundamental point, Your Honor, which is that Sharona shareholders got a big piece of a combined Dentsply Sharona company. It was misrepresented to investors that the market was highly competitive. That meant that all manufacturers in the business got the benefit of inflated prices. And in fact, we know that at the end of towards August 2017 and again August 2018, there were massive write-offs of over $1 billion due to anti-competitive concerns that were undisclosed and which we contend were related to the impact of the scheme being disclosed and dissolved. It is a matter of fact as to which company shares suffered the greatest loss. But there is no question that the prospects of the combined company, including Dentsply, were adversely impacted. If the trial court below had wanted more information or required more detail beyond what we set forth as a matter of notice pleading, should have allowed amendment. And the defendant clearly understands what the theory of the case is. The issue of what the impacted damages were here is going to be a very complex summary judgment question for expert witnesses. I really don't think that one could plead an enormous amount of detail in the complaint on that particular issue. It's clearly alleged as to what the theory of the case was. But clearly, the statement about a highly competitive market was not puffery. And what the court actually decided the dismissal on was the argument that, well, it's immaterial unless there's an allegation that the parties involved somehow actively participated in the anti-competitive scheme. First of all, there's no authority whatsoever for such a rule. It's like, if you have a factory that's on the verge of sinking into a sinkhole, it doesn't matter whether you helped cause the sinkhole or not for there to be a duty to disclose to investors that a sinkhole is likely to envelop one of your major factories. The participation rule doesn't exist, and frankly, we met that requirement in any event.
Counsel, would you please be sure to address the statute of limitation issues?
Certainly, I think that there's a confusion again on the statute of limitation issues, which again, the court below found properly was not adequate grounds for dismissal here. It's a highly fact-intensive inquiry. There was no noticeable decline in the price of the combined company until August 2017. And at most, there was a disclosure of, for example, the exclusivity agreement, which relates to the excess inventory in the channel.
Were there a lot of fluctuations in price between March 1st, 2016 and June 7th, 2017 when the complaint was filed?
Your Honor, if you look closely at, well, the issue is when the complaint was filed, when the first complaint was filed, which was in July of 2017. There were not significant stock fluctuations. The stock price basically fluctuated within a band of the high 50s to the high 60s. The exchange ratio, the price was around $60.96. It was rarely below $60.96. And to say that an investor is required.
Counsel, if I may, when do you believe the statute of limitations began to run?
Your Honor, in August 2017, because that's when not only was there disclosure, for example, of the exclusivity agreements having been terminated, but that in fact, there was this gigantic mountain of unsold inventory at Patterson. Previously, defendants' disclosures had said, oh, well, we may have declining sales because Patterson, the distributor, is devoting fewer sales resources to selling the product down. Yes, it was already known that the exclusivity agreements would not be extended, but there was no disclosure that the real problem here was that there was this undisclosed mountain. And I would just refer, Your Honor, to the SEC order, which we've submitted to the court by separate motion and as supplemental authority, which I think makes clear that there's no dispute that as to the stuffed inventory allegation, an item 303 allegation has been adequately pled. That there was an item 303 violation. The only question is the adequacy.
So you don't believe, I'm sorry, just one final question. So you don't believe that the statute of limitations began to run from February 2015 when the registration statement and the joint prospective were filed?
Your Honor, the statute of repose runs from that date, but not the statute of limitations.
Thank you. You have some rebuttal time. Mr. Malloy?
Good afternoon, Your Honors. May it please the court. Justice Renwick, just picking up on your point about whether these alleged non-disclosures impacted Sirona as opposed to Dentsply, I think that's an important fact. Sirona, the plaintiffs here are representing a class of Sirona shareholders. And they're basically claiming that Dentsply in the registration statement failed to disclose problems that were affecting Sirona's stock, that were affecting the value of Sirona's stock. That's all of the allegations relating to this inventory buildup at Patterson, all concern Sirona. So those, even if that information had been disclosed, essentially plaintiffs are arguing, I exchanged my stock for a stock in this combined company, but I wasn't told that my stock was actually worth less than I thought it was. Courts have said that that's not material, that there's no way that non-disclosure could have caused a subsequent loss. So the only possible claim that they could assert here relates to some non-disclosure relating to Dentsply's legacy business. And the only thing that they allege there relates to this distributor conspiracy. Dentsply and Sirona both distributed some of their products through big distributors that had 80% of the market of. They were the middlemen. They were the Amazon if you wanted to buy something from an Amazon marketplace dealer. They were Apple if you wanted to buy an app off of from a developer that was developing for Apple iPhones. And their theory is that conspiracy was somehow inflating the profits of Dentsply and Sirona, even though they weren't involved in the conspiracy. And there's nothing in the complaint except their say-so that was happening, and it doesn't make any sense. If I'm a developer of software, a manufacturer of software, like Dentsply is a manufacturer of dental supplies, and I can only sell my product through Apple to iPhone owners, that's not a good thing for me. I benefit if there's more competition among my distributors, and I'm harmed if there's a concentration of market power there. And that's exactly what the Supreme Court held in the Apple case that we cited in our reply brief. They said that the manufacturers can be injured just as much as the end consumers if the middleman in the process is engaged in anti-competitive conduct. So this whole set of allegations relating to this anti-competitive conduct has no chance of stating a claim. And further, they allege that that this somehow impacted Dentsply's statement about the competitiveness of the dental supply of the supply manufacturing business. But these distributors were not manufacturers; they weren't competitors. They were customers. They were the people that Dentsply was selling their products to. So when Dentsply said that their business was highly competitive, they were talking about other manufacturers of toothpicks and trays and picks and drills and things like that. They weren't talking about competition among their distributors. So no reasonable shareholder would have construed the omission of information about the distributors' alleged illegal conduct in fixing prices among themselves as somehow undermining Dentsply's statement about competition among dental supply manufacturers. And so, and then
why don't you address the statute of limitations in your limited remaining time?
On the statute of limitations, Justice Scarpulla held that there were fact issues about when the statute of limitations started to run. She didn't say what those fact issues were. In the briefs, the plaintiffs have framed the issue as a purely legal one. They say that they didn't know they were damaged until the stock started to drop in August of 2017. By then, the distributor conspiracy had been in the press. It had been the subject of lawsuits. All these things were drawn into the complaint. The allegations themselves come from sources that were public well more than a year before the lawsuit was filed. And so the legal question is whether damages are required to trigger the statute of limitations, and they're plainly not. You don't even, the Second Circuit's held that damages aren't even an element of a Section 11 claim. And Section 12 allows for rescission, so it's not an element of a Section 12 claim either.
So counsel, make it easy. When do you believe the statute of limitations began to run?
Excuse me.
Well, there's two sort of groups of claims. There's the claims relating to the distributor conspiracy. We believe that those were the statute began to run when those facts became public. The facts alleged in the complaint come from a pleading that was filed in federal court against the distributors, not against Dentsply. That was filed in I think May of 2016.
Thank you, counsel. We're back to you, Mr. Fredericks. 2 minutes.
Yeah, briefly. Look, this argument that no one could have benefited from this scheme because the inflation was at the distributor level is patently phony. We know from the record that more of Dentsply's sales were done through distributors than Sirona, because again, a lot of Sirona's products were sold through this exclusive arrangement and so not sold in a competitive manner. But if you're a group of airlines that are conspiring to set prices on the route from New York to Boston, and you're another airline which isn't part of that conspiracy, but you're seeing in the market that, hey, 80% of the market for that route has an inflated price, of course you're going to be able to gain an undue advantage from that because you're going to be able to price your product at a higher price relative to others because those have been set higher. And in terms of the case law that Mr. Malloy responds to, I think if you read the cases very carefully, they'll say the statute of limitations does not begin to run until all the underlying facts are sufficiently disclosed. The fact that the impact of these disclosures of this conduct was not disclosed until impairment charges amounting to billions of dollars were announced in October 2017. That would not put you on notice that these were material. The registration itself says you should believe only what's in the registration statement, but Mr. Malloy says, oh no, you should take notice of all these other things outside the prospectus and assume they're all true, even though the registration statement says, no, look only at the truth of the prospectus. This is a prospectus case. The standards are very high for truthfulness. In terms of the motion to vacate, we've briefed that thoroughly. I think that as we've explained, under either New York or federal law, under the normal circumstance, we clearly would have been able to replead in a new action. And I think the district court, thank you, Your Honor. We rest on our brief.
Mr. Malloy?
Yes, Your Honor. On this analogy to airlines, Dentsply and the distributors were not all the airlines. They were, maybe Dentsply was an airline and the distributors were travel agents. The fact that travel agents are conspiring to hike their own prices that they resell products to their customers for doesn't mean that the airlines are making money off of that unless there's some other facts that aren't alleged in the complaint. That's the fundamental disconnect here. Dentsply didn't compete with the distributors. On the statute of limitations, I think you'll if you go through the record, you'll see that Dentsply had already disclosed that a substantial amount of inventory was sitting at Patterson, that the Patterson was not going to renew its contracts, and that this was going to impact sales going forward significantly. So that's the omission that they claim was missing from the registration statement. And it was known when Dentsply put out, at the latest, when Dentsply put out its 2016 10K, which was more than a year before this lawsuit was filed. So again, it's just a legal question whether damages are required to be pleaded, and they're plainly not. The statute doesn't require it, and the Supreme Court says you have to look at the statute to see what triggers the running of the statute of limitations.
Your mic is off.
Thank you. Thank you both is what I said. Thank you both.
Thank you, Your Honor.
Thank you, Your Honor.
The final case is Ryan versus the City of New York. I'm recused from that case. Justice Manzanet is vouched in, and Justice Scarpulla will return. Have a good afternoon.
Thank you. We'll wait for Judge Scarpulla to rejoin us.
Yes.
Wonderful, there she is. Mr. Fingston, I believe you've been granted 5 and 2. You may proceed.
Yes, thank you, Your Honor, and good afternoon, and may it please the court. Again, my name is Neil Fingston, here for the plaintiff appellant, Carla Ryan. The trial court erred in dismissing the plaintiff's malicious prosecution claim as a matter of law. The record here shows, or at a minimum raises issues of fact, as to the defendant's employees knowingly providing the police with false and incomplete statements about Ms. Ryan's purported theft of $914.20 in the form of salary and car fare reimbursement by her submission of inaccurate time records and car fare reimbursements. The trial court order makes no reference to this difference in testimony, the falsity of the testimony. The defendant's motion for summary judgment doesn't account for it. And here in this court, the defendant's brief is silent as to the fact that the defendant's witnesses gave the police a version of events, which they twice acknowledged implicitly, both at the criminal trial and at the administrative hearing, were false. Both witnesses, the principal of the program and the chief investigator, acknowledged under cross-examination that Ms. Ryan was and was always entitled to her full salary, entitled to her full car fare reimbursement, even if her forms were inaccurate. The only reason that the police had any reason to believe that Ms. Ryan had stolen money is because these two witnesses told that to the police and told that to law enforcement authorities. This, as the record shows, should have been an administrative proceeding and only an administrative proceeding. If there was some issue about the teacher's submission of inaccurate statements.
Counsel, this is Judge Gonzalez.
Yes, Judge.
But where is the malice? Where is the malicious prosecution? I know you're going through a litany of facts as you see them, but it's the Bronx District Attorney in this case who decided to prosecute. The witnesses can't decide to prosecute. The police doesn't decide to prosecute. The Department of Education doesn't decide to prosecute. Wasn't there probable cause to the extent that there were inaccurate entries in the log?
Respectfully, no, there's no probable cause here. While the decision to prosecute is the district attorney's decision, it's the underlying facts that are really crucial here. The facts that the police were provided with, the facts that the district attorney were provided with were untrue. They were told that Ms. Ryan had stolen money effectively through her submission of these erroneous records. It's up for the district attorney to then decide whether—
Let's clarify, erroneous records that she created. She submitted inaccurate records saying that she was teaching a child who was hospitalized, who in fact was being taught by another teacher. So it's not exactly erroneous records. You know, I think the precision in the language would be helpful here.
There were records that falsely indicated that she had taught a student that she did not in fact teach, and we're not disputing that, and we're saying that that should have been solely an issue for an administrative proceeding. The important fact here, though, is that as the investigator and the principal both acknowledged in the criminal trial and the administrative proceeding, is Ms. Ryan was still entitled to her full salary, even through the submission of those records. She's still entitled to the car fare reimbursement, regardless of the submission of those records. The fact that the police were provided and the fact that—
Mr. Thingston, her entitlement to pay was premised on the fact that she had taught other children on that day.
Correct.
Correct?
Yes.
But it wasn't, if the system were such that she got paid separately per child, there would have been an issue.
It would have been a different set of facts, Your Honor, yes.
Right, okay. And in terms of the car fare reimbursement, was that a per day reimbursement or a per trip reimbursement?
The record shows that after a teacher makes, and there's a little differential here, 1 or 2 visits to a student's home, they are entitled to the car fare reimbursement, whether it's 2 students or 3 students or 4 students. So in this case, as the investigator and the principal acknowledged, and I will say the respondent, the defendants in their brief acknowledged, she was entitled to full reimbursement on each of the days in question for car fare. So the important fact here, and why there's no probable cause, is because while it was the decision to prosecute from the district attorney, the facts were that she was entitled to that money.
But are you saying that when the Department of Education referred this matter to the district attorney's office for them to consider whether charges should be brought, that they somehow kept from the Bronx District Attorney's Office the DOE regulations that you were referring to and that were considered in the administrative hearing as well?
Well, a couple of things, Your Honor, if I may. The letter that was sent off to the district attorney doesn't talk at all about the salary issue and entitlement to salary. So this was something that was specifically, from the record, it appears, brought up by the investigator and the principal in discussions with the police, this idea of a theft of $914.20. As for the regulation that Your Honor referred to, that regulation didn't come up anywhere during the arrest, during the prosecution. It's not mentioned on the defendant's motion for summary judgment. And in fact, the testimony, it's not shown to apply to Ms. Ryan specifically. It's talked about in the administrative proceeding as a something that exists. Hypothetically, this is what may happen to a teacher, docking pay under certain circumstances. It's not shown to apply to Ms. Ryan. The regulation talks about in-school teachers. Ms. Ryan is not an in-school teacher. Also, the ultimate testimony from Mr. Henry.
But wait a minute, but does DOE have different rules for teachers who teach in a school versus teachers who are accommodating children who, for whatever reason, cannot physically come to school?
It's an unresolved issue, Your Honor. And the reason it's unresolved is because the defendants never addressed it in their motion in the lower court, never in the criminal prosecution.
No, my question is not whether there's been a case before that has resolved this issue in a court of law. What I asked was whether there are any distinct DOE regulations that are different for teachers who teach outside of the school than teachers who teach inside of the school.
Right,
I know of no such difference.
I apologize if my answer wasn't clear. My point was that in this particular case, the whole idea of the purported applicability of that regulation wasn't addressed at all. It wasn't raised at all until the administrative hearing, which was after the criminal prosecution and after the acquittal. And I will say that the testimony from the investigator and the principal at the administrative hearing, that Ms. Ryan was entitled to her full salary, entitled to her full car fare reimbursement, would undermine the idea that the regulation applies. They are acknowledging that she's entitled to all of that money. The defendants in their brief, page 5, page 26, acknowledges that Ms. Ryan is entitled to the money. A teacher is not a doctor.
Counsel, you're putting this within the category of malice as opposed to the category of there was a mistake in the calculations.
Yes, malice. To get back to your question from earlier, Judge Gonzalez, I didn't have an opportunity to address that. There's nothing in the record from the defendants to explain why it was that Mr. Henry and Ms. Ledesma told police that Ms. Ryan had stolen $914.20 and later testified at the criminal trial and at the administrative proceeding.
Judge Scarpula, your mic is off.
I see that. Wait, when you say there's nothing, the fact that she said she taught a student that she didn't teach that day, that's nothing?
No, Your Honor, I was talking.
She admits that she did not teach that student that day. Correct?
I was talking about in the context of explaining from the defendants, explaining why their witnesses came up with two different accounts for whether she was entitled to the money or not.
I'm sorry, Counselor. I do not understand what your argument is. I really apologize. She did not teach the student. Another teacher actually taught the student, and that teacher actually put in for the monies for teaching that student. Your client did not teach the student, yet she provided documents that she did in fact teach the student. And that is not something you should do. And that was what was referred to the district attorney's office. And they, I'm assuming, investigated, they prosecuted, she was acquitted. So I'm not really understanding what should not have been done. Are you stating that even though she didn't teach the student, and she stated that she did teach the student, that because she's paid a certain way, that it doesn't matter?
Yes, because the record shows.
Based on what? Based on what?
Because both the investigator and the principal at the criminal trial and again at the administrative proceeding both testified because Ms. Ryan had taught other students on the dates in question, she was entitled to her full salary.
I can understand your argument if perhaps when she was confronted, she did not specifically state that she had taught that student. Then perhaps I can understand where the log says that on this particular day, she taught students and did not specify what students. But what I do not understand is she specifically stated and specifically submitted documents showing that she taught this particular student. Not that there was an umbrella of students that she was responsible for and she just forgot or, neglected to delete this one student who happened to be in the hospital undergoing treatment for leukemia.
The fact that's not accounted for here is that the criminal complaint makes specific reference to the statements from the investigator, from the principal, that Ms. Ryan supposedly stole $914.
Okay, you've made this argument several times. You have 2 minutes on rebuttal. Ms. Ajibe? Did I say your name correctly? And please unmute your mic. Okay.
Yes, you did, Your Honor. Good afternoon,
You have
Your
5
Honors.
minutes.
My name is Wamika Ajibe, and I'm here on behalf of respondents, the City of New York, the Department of Education, Ms. Lesda. Appellant's case is premised on 2 central assumptions, both which are proven false by the record. First, the appellant claims that law enforcement, during their investigation of her actions, never learned that she was a salaried worker. And second, appellant claims that if they had known this fact, they would have never arrested her or never prosecuted her.
I don't think it's a question of knowing that she was a salaried worker. I think it's a question of knowing the nuances of payment for a day. So as was found in the administrative hearing, she was entitled to her full day's pay, notwithstanding her lie on the form. And that's the bottom line. So there was no theft.
I think that the perspective of the prosecutor is really the key.
It's a question of a perspective of DOE, because DOE is the agency who understands and is familiar with their regulations, of which there are thousands, counsel. So if you're going to refer, if DOE is going to refer a case to the prosecution, any prosecutor's office, it is incumbent upon DOE to provide the prosecutor with all of the information they need to make informed choices. You don't wait for someone to be prosecuted, get put through the system, only to find that they get acquitted because there is no factual basis for the charge. She lied. She filled out a form improperly. There's no question about that. And whether she should lose her job for that is something absolutely within DOE's confines to decide in the first instance. But to refer it for prosecution, knowing that on that day she had taught other children and therefore was entitled to her pay, is disturbing, to say the least.
Your Honor, the record doesn't show that the prosecutor wasn't aware of these nuances. In page 5 of Respondent's Appellant Supplemental Appendix, it's clear that the theory that the prosecutor used was that the theory that she didn't provide services as a salaried worker. Like any of us who are not a salaried worker, if we don't appear for 3 weeks and we don't do our work, our employer can think we're not entitled to the salary. But that wasn't the case here.
Your office knew that she had taught other children on that day and therefore was entitled, notwithstanding her lie. I'm not excusing the lie in the slightest, but was it a basis to have her arrested and prosecuted in a criminal court?
That's the question for the prosecutor's office, not the DOE.
Well, counsel, you represent the city, so you're representing the Bronx DA's office as well. Is that correct?
No, not in this matter.
Okay, so that was my question. That's what I did not understand. So the malicious prosecution is not as to the the Bronx District Attorney's office in this action. Is that correct?
That's correct. It's the actions of the DOE employees. Were they reasonable in what information they provided?
Okay, so you provided information to the district attorney's office, but it appears as if the information that you provided included petty larceny. There was no larceny in effect because she was a salaried employee. Perhaps it was falsifying business records, but no larceny. And that's the whole point. In terms of what was provided, you said the nuances, but the nuances are very important, right? Because you are referring this to the district attorney's office, so you are aware of the quote unquote nuances, and this should have been made aware to them when you're referring this for a possible criminal prosecution.
The information that's provided to the DA's office, the letter explaining the referral, sets out the facts in a clear manner as to what actually occurred. There's no indication that the DOE pressured the DA to bring any specific type of charges.
That's counsel. That's what I want to ask you. This is Judge Scarpula, right? For malicious prosecution, it has to be a lot more than just I referred it, right? So your argument here is you referred, but there's not that second half of I called every day and told them to prosecute. I did something more than referred, right? Is there any evidence that the DOE did anything else but refer and testify when the time came?
Yes, that's right. And the two employees signed, along with the mother of the student, supporting deposition. But there's clear case law in this this court that simply signing a supporting deposition is not enough for malicious prosecution.
So all you did was refer to the district attorney's office what exactly she had done or had not done or failed to do. You referred that to them. You did not state that she should be prosecuted for falsifying business records or that she should be prosecuted for petty larceny or any type of larceny.
No, the letter referring made no reference to any type of penal code or didn't request that she brought any charge. It was just to provide the information. And I think it's helpful here to highlight some of the facts that caused the alarm with the DOE employees. It's not just a simple case, which happens all the time, where a student doesn't appear for a session. But what we have here is that the assistant principal learned after 3 weeks that this student had been hospitalized, and she was completely caught unaware that the student had not been being served by a student in the home instruction program. She spoke with the teacher, and the teacher lied as she understood. The teacher claimed that she was teaching the student in the hospital, but yet she did not know the name of the hospital. She didn't know anyone at the hospital, and she had no documentary proof that she was making those trips. And this triggered an investigation to the DOE. They attempted to find any proof that she had actually been at the hospital.
I don't think there's a dispute that she did not teach at the hospital. We've all acknowledged that.
I think the point
We've all acknowledged that. That's really not the issue.
The point of the formal investigation is to understand that the DOE went out of its way to understand what happened here. And because they thought that this was a cover-up, a pretty serious one, it warranted passing on that information to the Bronx defenders. I just wanted to highlight.
Well, no, the Bronx District Attorney's Office. Anyway, you're out of time. Thank you so much. Thank you so much. We're out of time. Mr. Fingston, you have 2 minutes.
So, Mr. Fingston, what I do not understand, did you not sue the Bronx District Attorney's Office for malicious prosecution? It would seem to me that the claim or the issue would be with them.
Well, respectfully, no, I would disagree with that, because the district attorney was given a set of facts. The police were given a set of facts that were untrue. They were misled. They were led astray. The idea that Ms. Ryan—
They had a duty to investigate, because I say that you attacked me, you assaulted me, or that, let's do it in this context, that you falsified certain documents, and I send that on to the district attorney's office. That doesn't mean that they're going to automatically go into the grand jury or swear out a complaint. There has to be an investigation.
Right, and they did conduct an investigation. That investigation was a conversation with the principal of the school and the chief investigator, both of whom said that Ms. Ryan had stolen $914 and change. And then they later, 2.5 years later at the criminal trial, acknowledged that she was entitled to all of that money. They said the same thing again during the administrative proceeding. The letter that was sent to the district attorney's office—
Mr. Fingston, did your client pursue her administrative recourse prior to the trial?
I'm not sure what you mean by administrative recourse, Your Honor.
In other words, there was an administrative hearing held after the criminal trial.
Correct.
Did you seek to have the administrative hearing first, since that would be a lot faster?
The record doesn't show that, and I'm unaware of those circumstances. Okay. The conclusion of the administrative hearing was a reprimand and a conclusion by the hearing officer that she was always entitled to the money that we're talking about. So while the letter didn't include any of the information or reported facts about salary, it's clear from the criminal complaint that the investigator and the principal provided not only incomplete information, but false information. And the Ramos case that we cite in our brief court decision from this court, says that providing incomplete information to the district attorney, lying to the district attorney, does support claim for malicious prosecution. So,
thank you. Thank you.
Make one more sentence, Your Honor.
30 seconds.
We asked the court to look at the Thomas case cited in our brief, but decision by this court, and ask for the reinstatement of the malicious prosecution claim. Thank you all very much.
Thank you. Have a good night. This concludes the session of the Appellate Division, First Department. Good evening.
Thank you. Good evening.